Good morning. Can I welcome everyone to this, the 18th meeting of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. Apologies have been received from David McCletchie and Jenny Mara. John Lamont and Mark McDougall are attending as substitutes. Can I also welcome to the committee Lewis MacDonald and Chick Brodie. Others may join later, but I beg your pardon, I'm not Lewis MacDonald. Ian Gray, it's a bad start. Ian Gray and Chick Brodie and others may join during the course of the evidence. Item 1 on the agenda, decision-taking business in private. I invite you to agree to take item 6 in private. That's further consideration of our approach to the scrutiny of the Tribunals-Scotland-Bill at stage 1. It's proposed as a private item as we will be discussing possible witnesses. Are you agreed? Thank you very much. Item 2, our next is to take evidence from the Cabinet Secretary for Justice on one affirmative instrument, the draft Children's Legal Assistance Scotland Regulations 2013. I welcome the meeting of the Cabinet Secretary and Scottish Government officials, Kit Wyatt, Head of Children's Hearing Team, and Katrina McKenzie, Legal Aid Policy Manager. I can see it's Felicity Cullen, but I don't know who you are. The Legal Advisor, there we are. Well, you're welcome anyway, you weren't on my notes. I now invite the Cabinet Secretary to make an opening statement, please, on the instrument.
Thank you, Convener. I'm pleased to be here today to discuss the Children's Legal Assistance Scotland Regulations 2013, which make provision for state-funded legal representation in children's hearings and their associated proceedings. They detail how children's legal aid will operate and make ABWOR available to certain persons in certain circumstances. The regulations form part of implementation of the Children's Hearings Scotland Act 2011, which is due to go live on 24th June. The Children's Hearings Act strengthens and modernises the children's hearing system. The changes it introduces are focused on improving outcomes for children and young people and ensuring that the system is more child and young person friendly and that it is nationally consistent but locally delivered. As part of these changes, we're replacing the current interim arrangements for providing legal support to children and parents in hearings, which have been in place since 2002. These regulations will provide a permanent, sustainable national scheme for the provision of state-funded legal representation in children's hearings administered by the Scottish Legal Aid Board. Restrictions will continue to apply to the granting of this legal representation. For example, other than in urgent and emergency situations, it will need to be apparent that a child or parent needs that support in order to participate effectively in the children's hearing. That gives a very brief overview of the regulations and their context, and I'm happy to answer any questions.
Do members have any questions, please? I'm looking around. They apparently have no questions, Cabinet Secretary. So that seems to be fine. And now we move on to item 3, the formal debate on the motion to approve the instrument considered on private item. Would you ask your Cabinet Secretary to move motion S4M 6775? Thank you very much. I take it no member wishes to speak in the debate, I presume from no questions. Thank you very much. And Cabinet Secretary, you will not be saying anything further, I take it. Thank you very much. The question is that motion S4M 6775 be agreed to. Are we all agreed? Thank you very much. The Cabinet Secretary should know staying on to the next item. Can I thank the officials for attending, and I'll suspend briefly just to allow you to swap over 1 minute. Don't leave your chairs. Right, now we're all sitting comfortably. I shall begin. And I thank the Cabinet Secretary for staying for this item. And this is the item on Scottish Court Service and Evidence Session Shaping Scotland's Court Services. And I welcome Robert, obviously the Cabinet Secretary is still here, Robert Sandeman, Civil Law and Legal Systems Division, Cameron Stewart, Courts Reform Bill Team Leader, and Nicholas Duffy, Legal Services. Now, can I have a short opening statement, Cabinet Secretary, on the proposed court restructuring, please?
Convener, I welcome the opportunity to speak about the Scottish Court Service recommendations on a future court service. It may be helpful to the committee if I explain the constitutional position in relation to these proposals. The Scottish Court Service is an independent body corporate established by the Judiciary and Court Scotland Act 2008. Its board is chaired by the Lord President of the Court of Session. The 2008 Act was passed unanimously by Parliament, and it has the effect that the Scottish Court Service is now answerable to the Lord President rather than Scottish ministers. The working of the courts is therefore an operational matter for the Scottish Court Service and, of course, for the Lord President, who has a statutory responsibility for the efficient disposal of business in Scotland's courts. The SCS proposed the closure of certain Sheriff and JP courts. The legislation provides, however, that it's for Scottish ministers to lay the orders implementing these proposals before Parliament. These have now been laid, and I understand that the committee will be considering the orders at its meeting next week. Clearly, ministers had to satisfy themselves that the policy implemented by these orders is justified in the circumstances. Ministers have to consider the bigger picture, looking across all of the government's portfolios. We deliberated carefully on the options presented, particularly in view of the representations made in relation to particular courts, and the Cabinet has given its consent to the proposals. We think that the proposals strike the correct balance in the current economic climate. We're satisfied that the proposals measure up to the principles for provision of access to justice developed in discussion with the judiciary, specifically that most court users should be able to travel to their local court by public transport so as to arrive at the start of the case in which they're concerned and be able to return home by public transport the same day. The Scottish Court Service is not immune from the financial pressures caused by the severe cutbacks imposed by the Westminster Government, which affect all walks of life. South of the border, some 93 out of around 330 magistrates' courts are to be closed and 49 district courts. And according to the Times and the Telegraph, I understand that the UK Government is now considering privatisation of courts. For this reason, the Scottish Court Service is seeking to save £4.5 million from its revenue budget, and they estimate that the proposals will save almost £1 million per annum and an estimated backlog maintenance of almost £3 million. Although the Scottish Court Service presented its recommendations on 9th April and I gave my consent on 18th April, it's self-serving and misleading to suggest that consideration was rushed. The Scottish Court Service proposals were consulted on last autumn, and I've been aware of them since that time. And I regularly meet the Lord President and the Chief Executive of the Scottish Court Service to discuss these and other matters. I am reassured by the commitment which SCS have given to avoiding compulsory redundancies. I'm delighted that the Court Service made a commitment to introduce video links from the locations where Sheriff courts are being closed. This will assist cases like Rothesay, for example, where vulnerable witnesses will be able to give evidence in Rothesay rather than having to make the journey to Greenock, as is the case at present, because there are no vulnerable witness facilities in Rothesay. And it is significant also that Capability Scotland have indicated that they support the move of cases to courts which all have facilities for disabled court users. Many of Scotland's courts date from Victorian times and are not fit for purpose in the 21st century, and many are underused. Some others lie close to bigger courts where businesses will be scheduled more efficiently in terms of court and retrieval time. And although the court may be regarded as an important element in a community, this needs to be balanced against the fact that many similar and indeed larger communities function without a local court. The reality is that it's a better use of a shrinking budget to concentrate funds on a smaller number of better equipped courts where modern facilities are provided for victims, witnesses and jurors. And I welcome the opportunity to answer questions from committee members.
Thank you very much, Cabinet Secretary. Can I welcome to the committee Nigel Dawn and Lewis MacDonald? For the second time, Lewis MacDonald, but I'll tell you later why. Questions, please. John Finney, John Lamont, Graham Pearson. Right. Just indicate if you want on the list. Ian, is that you wanting on the list? Ian Gray, Sandra White, Alison McInnes, Chick Brodie, Margaret Google. Anybody else while I'm at it? Would you like to just all... Lewis MacDonald, let's just take the list. So I've got John Finney, John Lamont, Graham Pearson, Ian Gray, Sandra White, Alison McInnes, Chick Brodie, Mark McDougall and Lewis MacDonald. Starting first with you, John Finney.
Thank you, Convener. Morning, Cabinet Secretary. Cabinet Secretary, a recurring theme throughout the submissions we've had is the capacity of the courts to which business would be transferred to deal with the business that's coming their way. And among the factors suggested are the other court issues that are ongoing about business which would make its way down from the Court of Session at the present. How robust do you feel that case is, that the courts to which the business is transferred have the capacity to deal with it?
Well, I think it's very robust. Court business has been reducing significantly. You're right that there are other matters underway that will increase some aspects of it, but it's a very limited amount of business that will be transferred from the Sheriff Court to from the Court of Session to the Sheriff Court, and that amount is also, as I say, has to be taken into account that there will be a specialised Sheriff Damages Court in Edinburgh, unless it's decided to cite it elsewhere. So these matters have been dealt with. I've drilled down with the Lord President and with the Chief Executive of the Scottish Court Service. It's not in their interest to make matters difficult for them and their staff, but I've also spoken, for example, directly to the Senior Sheriff Clerk at Edinburgh, who is perfectly comfortable that he is under capacity, is perfectly able to cope with not just the incoming capacity from Haddington, but also that would come in terms of other matters in transferring work from the Court of Session.
Is that to suggest there aren't issues with churn at any of the courts that would be receiving that additional business then?
No, I think the current position is that there's undercapacity in some of these courts and they want to make best use and make it efficient. That's certainly the situation that I'm told by the Sheriff Clerk in Edinburgh. Clearly there is churn. It's a significant problem within the court service. Matters are being worked on there. This is part not just of how we change the structures, but how we do business, and whether, and under the Making Justice work, matters are being looked at and we're driving forward. These matters have been started with Sheriff Principal Taylor, Sheriff Principal Bowen, Lord Carloway. There are whole significant matters of how do we improve aspects of justice, how do we get people to courts, how do we make best use of our courts, how do we bring in technology, some of which is long overdue. And that, as I say, is why we're here. Some of these things cost money. Almost all of the proposals that the court service make, I think, are fully supported in terms of improving matters, but you've got to get the money and the savings from somewhere.
The Scottish Government's toolkit handling domestic abuse cases puts a great store on the time frame with which that business is dealt with. There's representations we've all received from Rossshire Women's Aid, the concerns that a service that's adequate at Dingwall will be diluted if it's moved to Inverness. There's also a proposal in there that clustering domestic abuse cases at Inverness, and this is something that could be mirrored elsewhere, would be a way of not only ensuring that all the support services are in place on a given day, but also with regard to other developments, perhaps build a specialism among sheriffs. Would you support the clustering of domestic abuse cases?
Yes, and I think that's supported both by the court service and indeed by the police. We do have specialist domestic abuse court in Glasgow. Some other courts we don't have the opportunity to do that. But for example, in Edinburgh, they do cluster. They have specialist sheriffs, so that it's sheriffs who have knowledge, who are doing experience matters, so that cases will go back before them. So I do support that. I think the points made by Rossshire Women's Aid are well made. They're points made to me by Scottish Women's Aid, who I meet with on a regular basis, and they're points I think that will and are taken on board, not just by the Lord President of the Scottish Court Service, but by Judicial Studies Institute, about how we get best deal with these matters. And part of that will also, as I say, be dealt with as we move towards law reform and summary sheriffs, where we will ensure that we get the specialist expertise and training. But I think the point of clustering, creating expertise, we see that in other jurisdictions. It works well, and I think the point is well made, and I've no doubt it will be taken on board.
I previously asked in Parliament, and indeed in my submission to the court review, for a specialist domestic abuse court in the Highlands, and that's obviously not been taken up. So what assurance, I mean, are you in a position to give an assurance that that format will be applied with the clustering?
Well, that would ultimately be an operational matter for the court, but I can say it's my understanding from discussions with the Chief Executive, with the Lord President, and indeed with those in charge of judicial studies, that we get the specialisation amongst those who deal with it, because it is a matter that does have to be specialised, that you do get the continuity that gives that experience and overall wisdom, that we do get the clustering. This is a matter that has been, as I say, supported initially by Dame Eilish Angelini when she was Lord Advocate, continued under the current Lord Advocate Frank Mulholland. It involves not just how the court position themselves, it's also how the Crown and the police position themselves. But it would be fair to say we've seen it in Strathclyde and other matters such as Marrick that mirror and add to the benefit of the domestic abuse court. So what I can say is there's a clear desire by all those who are involved in this, court, Crown, police, that we get specialisation, we get clustering, we deal with it speedily, efficiently, and as I say, it doesn't have to have the creation and establishment of a structure that works well in Glasgow because of its size. It can be dealt with in terms of good relationships between those bodies, and I can give you that assurance that each and every one of those organisations is committed, is working, and indeed there are clear areas where it is ongoing at the present moment.
Okay, thank you.
John Lamont, followed by Graham Pearson, please.
Thank you, Convener. Good morning, Cabinet Secretary. I've got two areas I want to sort of focus my questioning on. The first is the general policy objective behind these proposed closures, and secondly, I have some local concerns affecting my own constituency. Firstly, in relation to the overall policy objectives, is it not correct that the Scottish Government over the last 4 years have cut the court services capital budget by 80%?
Well, there has had to be cuts, but equally these cuts are less, I think, than what is taking place down south of the border. And I do think that this has to be borne in mind. We cannot have those who are party members and share the same allegiances as the coalition government down south. If I can quote from Jonathan Jangoli, the Under-Secretary of State for Justice, "It's unacceptable that dozens of buildings never intended and not fit for the requirements of a modern court system are still being used. It's undesirable in the current financial position that the taxpayer continues to fund buildings that offer outdated and inadequate facilities to victims and witnesses. Very few of us actually attend court more than once or twice in our lives, and even fewer use public transport to get there. It's simply not good use of taxpayers' money to operate courts simply to shave minutes off a journey that many will never need to make." I have to say those words are probably much harsher and more brutal than I would have expressed them, but I quote them because they come from your party member down south imposing greater cuts and indeed responsible for the cuts in budget that I have to account for and deal with and manage as the Justice Secretary here in Scotland.
With the greatest respect, I was asking about the Scottish justice system. I will repeat the question. Is it not true that the Scottish Government has cut the court services capital budget by 80% over the last 4 years?
We've had to make challenging decisions through the Scottish Court Service because of the significant cuts brought in by Westminster. These have affected every walk of life in Scotland. There is not one, I do not think, that isn't challenged because of the austerity forced upon us by the UK coalition government. So yes, I accept that I've had to make these cuts, but it has been the government policy that you support that has forced this upon us, when other governments elsewhere in Europe seem to take a different tack and seem to be achieving much more success, and yet you continue to listen to George Osborne and ignore the pleas of John Swinney.
Are you suggesting that the UK government's cut the Scottish Government's budget by 80%?
No, I'm suggesting that you've made significant cuts to every walk in life, and we have had to try and balance matters here in Scotland. I'm also suggesting, as I say, that it's quite clear that the Ministry of Justice is even considering proposals to privatise courts to save around £1 billion in England and Wales. There are hard decisions that have to be made by this government. We seek to defend the interests of justice. We seek to maintain a visible police presence in our community. We seek to maintain an integral civil legal aid budget that will allow for matters as opposed to the hemorrhaging of matters. So it gives me no comfort and joy to come here and require to preside over cuts. The reason I required to preside over cuts was the mismanagement of the economy of a previous UK government and the slash and burn actions of the current government.
I'll allow robust questioning back. So I think if we allow robust questioning back, John?
Yes, I've got some more questions. I'm far from clear as to whether the objective for these closures is about saving money or the delivery of a better justice system in Scotland. You're very confused in terms of the messages being given out. Either it's about saving money or it's about delivering better justice. Which is it?
Well, it's not either or. That may be in your world, Mr. Lamont. In ours, it's about both. And it's exactly the same as we have done in Police Scotland. We had to make the changes. We cannot ignore the fact that there are huge budget cuts, and we have to prepare for that. So we do seek to make the economies, and to deny that there are budget pressures would be to deny reality. Equally, as with moving to a single police service in Scotland that you opposed, we seek to get the best possible service.
We're actually dealing with courts, Cabinet. I've allowed you a bit of leeway because I want members of the committee to also be robust in their questioning, but I want to keep to courts. I'm
dealing with courts, Kabir, thank you. We are seeking to make the best use of the facilities that we have. The same position being taken south of the border where courts are outdated, underused, to make sure that we get the best possible service. We wish to make sure that victims and witnesses provisions are appropriate because many of the buildings do not provide for those who are vulnerable and require the most care. Equally, we also have to recognise that we have to have areas of specialist provision that Mr Finney has already commented on. So yes, the backdrop is that this is driven by financial cuts that we cannot ignore because we have to balance the books and are on a fixed budget. Equally, we do believe that the court service is right, that they can get a better, more efficient service out of this, that they can, by making the savings in buildings, provide the requirements and technology that everybody wants. They have to balance their budget. So, in a nutshell, it's driven by the requirement to meet the budget cuts, but it will provide a better service in the fewer buildings that are there, a better service that is long overdue, and a better service that will better provide for those who require to appear in our courts in whatever capacity.
Well, turning to the service that's been provided, or will be provided to the constituents I represent, looking at Dunn's Sheriff Court, the court services figures show that it was 330 cases heard at Dunn's Sheriff Court, and the JP Court sat typically for 25 days each year. If Dunn's Court closes, residents in Berwickshire will have to travel to Jedburgh Court. Could the Cabinet Secretary perhaps outline how a witness or a victim is expected to get from Eyemouth to Jedburgh Court using public transport in one day?
Well, as I say, I think I answered previously in Parliament, Mr Lamont. The statistics I have are that in 2011, 13 summary trials proceeded to have evidence led. In 2012, 12 trials proceeded to have evidence led. So yes, there's one trial a month that will have to move from Duns to Jedburgh. In civil matters, there were no civil ordinary proofs which proceeded in 2011, and there were no civil ordinary proofs that proceeded in 2012. So nobody who required to give evidence in a civil proof will require to go to Jedburgh. But yes, there is clearly, as I say, a matter in terms of having to move to Duns to Jedburgh, but these matters are looked at by the court service. They're taken into account by the Procurator Fiscal's Office in respect of witnesses where may be vulnerable. So these aspects have been taken into account. But I do think you should not seek to overplay your hand when we only have one trial a month and no proofs ongoing at Dunn's Sheriff Court.
So you dispute the contention of Sheriff Kevin Drummond 2 weeks ago and others within the legal profession in the Borders who clearly take a very different view to your own?
I'm going on the evidence that shows the clear statistics that show just what the business in Dunn's was. 1 trial per month, no proofs.
John. Graham Pearson, followed by Ian Gray, please.
Good morning, Cabinet Secretary, and good morning, fellow panellists. You would know that we've received a fair list of people who've made representations to us about their concerns in respect of court closures. So this is not merely a matter of politics, it's a matter of providing service, an appropriate service. Earlier you talked about churn in a different context, but it was suggested to me by one of them, and it came from Scottish Borders Council, that what in effect was happening in their area was that the costs of providing justice was being churned to other partners. So that although within the court service budget allocation, it looked as though some savings may or may not have been made, other partners were then faced with higher and additional costs. The second point that was made to me in that connection was that Scottish Borders Council certainly felt that the level of consultation was particularly poor, in that they had made an offer to cover, in relation to Haddington Sheriff Court, the costs that the court service had identified as amongst the savings that could be achieved, and that they had received no feedback and certainly no depth of consultation on that issue. How do you feel about the notion that many of these costs will be churned onto other partners, and that amongst those partners there's a feeling that they haven't been adequately consulted about the impacts?
Well, I have to say, I was meeting with representatives of Police Scotland yesterday, and these are not concerns that the Chief or any of his staff have raised with me. They're not concerns that have been raised with me by ADSW, nor indeed have they been raised with me by the Scottish Legal Aid Board, so I'm not sure just what partners you are referring to.
I mentioned Scottish Council particularly, the Borders Council.
Well, I don't see how the costs would be passed on to them, but I'm happy to try and answer, but I don't see where the cost implications for them as such would come from. The implications are more, as I say, for those involved in social work, those involved in the Crown, those involved in police, and indeed those involved in legal aid matters, and none of them have made any representations to me. In terms of Scottish Borders Council, I do believe that there's been engagement and liaison between the Scottish Court Service and Borders Council, in particular relating to the possibility of a justice centre in Galashiels. I think with regard to Haddington, that's referring to East Lothian Council. I do know that the Chief Executive spoke, I think, briefly with the Chief Executive of the Scottish Court Service. There was an indication that they may be willing or prepared to pick up some of the small costs related to the court. They weren't prepared to pick up the larger costs, I think, which didn't drill down to the discussion of who would be responsible for the almost £500,000 outstanding repair bill. So I think the suggestion that the Scottish Court Service were not prepared to discuss matters is not true. I just think that perhaps East Lothian Council were not prepared to read the script as to what the cost implications would be. A token offering to provide some support for Haddington is not what the Scottish Court Service would have been expecting.
Yeah, I think it's unfortunate that you would imagine that the Council's senior officials and the leader of the Council would utter untruths in this matter. They certainly feel that they've been neglected in terms of their consultation, and I think that that's also reflected by some of the other councils. Indeed, East Lothian is also included in that list of people who feel that they haven't been adequately consulted, and I would hope that you would go back to the drawing board and ensure that these consultations should be completed properly. Let me change the subject because I'm conscious of other questions to be offered. You mentioned the Telegraph this morning and the comments in the Telegraph in an earlier part of your responses. I read the Telegraph this morning, and there's a commentary there about the disarray in the way trials are handled in England and Wales, and the usual picture is presented of witnesses, lawyers, accused, victims milling about hoping to get heard within the court environment. And a separate issue with the Justice Committee, we heard from victims here before the committee in relation to another piece of legislation. And they reported too, very often, that they were called to courts and loitered about as nothing happened. You also mentioned the use of video links and new technology. And in the papers that have been presented to us, as much as that is a laudable hope for the future, there isn't a huge evidence there that shows it's being effectively used currently. Surely the whole prospect for the future should be about delivering a service to vulnerable witnesses, witnesses who attend these locations, and the victims who are already in a great deal of stress, to provide the best possible environment for them. And a lot of the submissions that we've received in the last few weeks indicate that your proposals do not provide for that best possible service. Can we be sure that we manage our trials and our appearances effectively, and that that element of churning cases to other locations, that capacity is available and will be used in a way that will be effective for those people using courts?
Well, that is what the Making Justice Work programme is about. It is about trying to make sure that we minimise the disruption. There will always be some, because you know from more experience than I do, Mr Pearson, that there are some who will only attend when they are absolutely required to by the enforcement of a police warrant. That is the nature of their relationship with our society and our laws. There are others that it comes about in other ways, and there's been good work and progress made by the Scottish Court Service and by the Crown and the police working together. But I also think that we should also realise that I think the system in Scotland, the glass is half full and getting better. I was with the Director General Designate for the National Crime Agency yesterday, and I think they see good work up here, and we work with them to learn from south of the border, but equally we can hold our heads high. I attended the Victim Support Europe conference last week, hosted here in Edinburgh by Victim Support Scotland, and again, we are up there in European terms as doing a good job. So there are challenges for all. The links are ongoing. I think in technology, a bit probably like what we face in our own lives. You have to get the broadband capacity in. You have to train up the sheriffs and the clerks to be able to do it. Many of these buildings were not suitable for some of these matters, but that work is ongoing. And what we will be seeing, and we've had the commitment from the Chief Executive in the areas and communities in which the court is closing, as Mr Finney raised at a previous matter, you have a clear commitment by the Chief Executive that video links will be going in. And indeed, those video links, as Capability of Scotland were saying, will provide better facilities for vulnerable people than are currently available, because sadly, many of the buildings that we are closing do not provide for vulnerable witnesses, which is why at the present moment people have to go from Rothesay to Greenock, despite the fact there is a court in Rothesay at the moment, because they are vulnerable because the facilities are not there. What this will provide is that they will be able to give their evidence by video link from Rothesay. So there will be improvements. I can give you a clear assurance that every area, Crown, Police and indeed Court Service, recognise that, and it's working together. The Making Justice Work system is about partnership working, because one silo cannot operate independently from the others.
I'm grateful for the clear assurance. Last question, and it's entirely a matter for this committee post your appearance later, but procedures allow this committee to make a decision about closures or otherwise without going to Parliament, to the Chamber. As a parliamentarian, in the interests of democratic accountability, would you agree it would be far wiser to allow the Parliament to decide this issue and encourage us to move in that direction?
Well, I think what we have to do is recognise that we have to deal with these matters as expeditiously as possible. This was provided by the Judiciary Act that all parties signed up for, all parties voted for. This is, as I say, a matter in which consideration is given by the Lord President and the Chief Executive of the Scottish Court Service. I narrated at the outset why it was agreed that government would have to look across portfolios. That has been done. Parliamentary committees are here to give great scrutiny, to be able to drill down and to question me that cannot be done in the floor of the chamber. So it seems to me that the best and most efficient way, which is why we drafted the legislation that was supported by every party represented here today and represented in the Parliament, was to deal with it through the committee, unless the committee should decide otherwise.
That sounds like a no.
Just to clarify that this is just following the statutory procedure for negative procedure. Of course, there are other options, but that would normally be the process, simply a guiding thing. Can I say to those, Roderick Campbell, who wants a supplementary, because I've got so many, I normally take them, I'm not going to do it today, I'll just let everybody come in, otherwise I might have a whole lot of supplementaries. I might also add that because I'm sitting in the chair, I'm not going to ask questions about my own constituency for clarification. I think it would be unfair in a sense, so it's tough for me, but I'm not going to do it. So I make that point now in case anybody wonders why I don't mention the courts in my constituency. Ian Gray, followed by Sandra White.
Thank you, Convener. In your introductory remarks, Cabinet Secretary, you outlined the responsibilities in this matter, and you pointed out that the Lord President has a statutory responsibility for the efficient disposal of business in our courts. I'm looking at the Lothian and Borders Sheriffdom performance reports from April, which is the last month available, and the percentage of cases disposed of within 20 weeks is in Haddington 83.8% and in Edinburgh 58.4%. Justice of the Peace Court, the figures are essentially the same. I wonder if you can explain that if what we're pursuing here is the efficient disposal of business, how that's achieved by closing an efficient court and moving its business to an inefficient one.
Well, I don't believe that Edinburgh Sheriff Court is inefficient. It has its challenges, but it's a better court and facility, having appeared as an agent in both. I'm aware of that. There are, for example, no dedicated witness facilities within the court at Haddington, a matter that Mr Pearson was just asking for. And it's important also to put it in the context that these court closures are not taking place in isolation. They are part of civil law reform. They are part of the Making Justice Work programme, and that is why the Scottish Court Service have looked at this. They have a number crunched, and they are confident that they have undercapacity in Edinburgh, that they will be able to deal with matters, and as further changes come through, as the technology goes live, we will see an improvement.
Well, that all may be true, but the target that Scottish ministers, that's you, sets for our court says that the percentage of cases disposed of within a 20-week period should be 85%. Edinburgh is currently achieving 58.4%, in spite of the fact that you told us that the Sheriff Clerk has assured us that he's content that his court is operating under capacity. So his court is under capacity, and yet it's missing your target by a very significant degree. My local court is delivering very close to your target. Why are you going to close my court and move it to Edinburgh?
Well, I don't think it's your court as such. You are the elected representative. It covers a wide area of the county of East Lothian, originally Haddingtonshire, but things move on. I know you've spoken in Parliament about how it was there pre-Reformation. Equally so in the statute book were a whole variety of other matters that have had to change from capital punishment down through the stocks. So life moves on, as indeed does other matters there. I also, though, would refute your caustic view of Edinburgh. I think that Edinburgh is doing a good job. They have specialist facilities on domestic violence, for example, that Mr Finney correctly raised, that I think are envied in other areas, and we need to provide for that. Various matters that currently happen in East Lothian actually get dealt with in Edinburgh because of the requirements for witnesses, whether it's in terms of vulnerable witnesses or juries. So these are matters that we have to, as I say, address.
I'm sorry, Cabinet Secretary, is this or is this not your target? Is this or is this not your target whereby the performance of courts are judged?
Edinburgh Sheriff Court is under capacity. Edinburgh
No, it's
Sheriff
underperforming.
Court, Edinburgh Sheriff Court, I think Edinburgh Sheriff Court is doing a good job in dealing with matters that come before it. It has the, as I say, facilities to be able to deal with matters, to provide the security, to provide better facilities for those who are vulnerable, which is why some matters that currently happen and should probably jurisdictionally go to Haddington, go to Edinburgh to provide for that. That was the situation in my day when I appeared in courts where various jury matters and matters relating to children would be transferred to Edinburgh because Haddington Court was not viewed as appropriate. But as I say, Edinburgh Sheriff Court is able to deal with it. Edinburgh Sheriff Court will deal with it, and I have the utmost faith in the court service, whether in the Chief Executive or indeed the Sheriff Clerk, to be able to provide for that.
Well, I remain puzzled by how the Cabinet Secretary judges the performance of our courts if it's not by their achievement or failure to achieve his own targets. But if I accept that he's content with the performance and the handling and efficient handling of business at Edinburgh Sheriff Court, is he content then that the current cost per sitting day in Edinburgh at that Sheriff Court is over £4,000, whereas for comparison, for example, Haddington Sheriff Court, the cost of a sitting day is £2,415. So if this exercise is not about the efficient delivery of justice, which I have to say it appears not to be, if it is about saving money, then can the Cabinet Secretary explain to me how we will save money by closing a cheaper court where business is expedited at lower cost and moving that business to a court which costs twice as much?
Well, I will attempt to explain to you. The court business of Haddington will be absorbed within the Edinburgh Sheriff Court building without adding to the Edinburgh overheads. The accommodation costs, utilities, rent, rates, water of Haddington will cease, never mind the backlog maintenance budget of £500,000. The same costs for Edinburgh may increase, but only marginally. The combined staff costs will be the same as they are now. The combined judicial costs will be the same as they are now. Since Haddington generally only operates one court per day, while Edinburgh operates on average 12 per day, to achieve a more realistic comparison, the Edinburgh figure has to be divided accordingly. Therefore, I don't think that you're comparing apples and apples. You're comparing apples and pears, and the savings are there to be made. They have been number crunched by the Scottish Court Service, and they have been reviewed by us.
Well, the STS, in terms of that number crunching, uses a calculation of gross internal areas to compare running costs, which gives us running costs in Edinburgh of £81 and Haddington £72. So I'm afraid that by any measure, in fact, business in Haddington Court is cheaper and more efficient than in Edinburgh, and that's the court you're going to close. But I just wanted to close by coming to silo thinking. The Cabinet Secretary said the important thing was we didn't operate in silos, and he made reference to East Lothian Council, who've very much taken that broad view and recognising the cost to them in additional travel, for example, for social workers and to the towns that they represent, for example, the economy of Haddington. They have made a number of generous offers to the Scottish Court Service, which I'm afraid the Cabinet Secretary dismissed as token. They have offered to make a substantial contribution to the running costs, the ongoing running costs of the court to avoid closure. And just to inform the Cabinet Secretary that I have here an email from the Chief Executive which shows that they have in fact offered to pick up half the cost of that £500,000 backlog maintenance. So I wonder if the Cabinet Secretary would like to apologise to East Lothian Council for dismissing that as a token gesture.
Well, what I would like to put on record is, first of all, average period between first calling of a summary criminal case and trial in Haddington is 15 weeks.
Well, you might want to do that, but my
well,
question is about the offer which has been made by East Lothian Council to pick up the costs in order to avoid closure.
I'm more than happy to address that, Mr Gray, but I would be in dereliction of my duty if I wasn't to provide some additional information to a previous question I now have that I think would be of benefit to the committee. So if you would do me the courtesy, I'll put that on record and then address the second matter.
I'll do that if you do me the courtesy of responding to the question I've asked you now.
I will
ask the Cabinet Secretary to answer your second part.
The average period between first calling of a summary criminal case and trial in Haddington is 15 weeks, and in Edinburgh it's 17 weeks. The corresponding period for civil business between allowing and calling a proof is 12 weeks in Haddington, but it's only 6 weeks in Edinburgh. So I believe that the service offered in both courts is relatively consistent, in some areas better in Edinburgh, and it's that we will seek to build upon. Obviously, contractual arrangements are a matter for the Scottish Court Service, but they have stated to me that there was a tentative offer, no details were discussed, and they would not expect to recover all costs of the court operations. And indeed, you've said yourself that it was a 50% offer relating to one aspect on maintenance. And in addition, as I say, it doesn't address the vulnerable witnesses and other matters. So I think, and I hope, that you will accept that now puts on record both the previous aspect I've clarified from a previous question and answers and puts on record the point you've made about discussions between East Lothian Council and the Scottish Court Service.
My question was whether you would be willing to apologise for the incorrectness of your previous answer where you stated the East Lothian Council had refused to consider a share of the £500,000 backlog. That information is out of date, Cabinet Secretary.
I've put on record the position of the Scottish Court Service in their discussions.
Mr Gray. And now Sandra White, followed by Alison McInnes.
Thank you very much, Convener, and good morning, everyone. Yes,
good morning.
It's still morning. It seems like a long morning already, yes, even in Glasgow. I wanted to be mentioning about building, etc., and I think Ian Gray mentioned about the efficient delivery of justice. But I want to also talk about the people who are going forward, such as the witnesses and obviously the accused as well, about access to justice also. Now, the court structures, but we're looking at the whole thing, and Graham Pearson's absolutely right. We have received this huge, deluge of papers from various people there. But one thing that's not been mentioned this morning so far, and I don't even think it was mentioned within the papers, the submissions that we received, is regarding access for, yes, vulnerable people, but children in particular, and children's hearings. Now, I know that I think in previous evidence sessions we heard that children's hearings, particularly in Dundee, are not, through the courts, through offices, and I just wondered to ask the Cabinet Secretary or others, is this something that we're going to roll out, to other areas, with the court structures? It seems to work very, very well in Dundee. Certainly some of our witnesses previously had mentioned that. And the other issue, if I may pick up on it, was Graham Pearson had mentioned it as well about the video linking, and I think the Cabinet Secretary mentioned Rothsay. And I know that Ian Gray and others about the buildings, but certainly Children First had said that some of the buildings weren't fit for purpose, and certainly victim support supports more of the video linking. So I just wondered if the Cabinet Secretary or others could say, let me know, or let the committee know, in the video link issue, has expansion taken place, and have we any examples of where it has been expanded to, how successful it is, or is there expansion going to take place to enable vulnerable witnesses to basically not have to travel?
Well, I think there was two matters. I think the Dundee Sheriff Court, matters were raised by Kevin Drummond, who I know and have the highest regard for, about almost peripatetic courts. I think the position that I can put on record from the Scottish Court Service is there are some matters I think could never be moved out. There are instances, and I have, as an agent, taken evidence from and where evidence has been taken in hospitals, or indeed evidence taken on commission in people's homes. But some criminal matters, I think, will always require to be dealt with within the court for the security of those who require to give evidence, and never mind other aspects. There are matters, though, where there is a possibility to see what could be done out with the normal court building. I do recall that when I did practice law, whether in Haddington or Edinburgh, I did also appear in Dundee. Referrals from children's hearings in Dundee were dealt with not within Dundee Sheriff Court, but they were dealt with within the building that housed the reporter to the children's panel. That would be where the young people would have been going. It was the sheriff that travelled there. I made inquiries, and I can indicate that is still the position in Dundee. It's the sheriff that moves there. Equally, I'm delighted to say that the Scottish Court Service is in consultation with the Scottish reporter to the children's panel about whether that can be dealt with in other areas that would be able to provide for it. So there's a general willingness to recognise it in some of these matters. Hearings and referrals from children's panels where the grounds are not accepted, maybe it would be more appropriate that the forum in which it is heard is in fact the Children's Centre, not the Sheriff Court. These are matters that they're engaging with SCRA about. Some of it won't probably be possible because of the size of the SCRA office, but it might be possible. Equally, they are willing to look at other aspects that may arise, whether it's in terms of adults with incapacity or some other areas of law. They are considering that, where the nature of it probably means that it would be better dealt with somewhere less of such a legalistic environment. It applies with children, and as I say, there's a willingness there, and I welcome that from the court service, and they're willing to look at elsewhere, and that's the matter. In terms of video linking, there will be new secure live link video conferencing network in 6 northern courts: Aberdeen, Elgin, Inverness, Kirkwall, Lerwick and Stornoway, and 4 other locations. They are due to be completed in June, which will help, that's this month, reduce participants' needed to court. So I can give both yourself and Graham Pearson a clear undertaking that matters are being dealt with to try and accelerate the technology. Some of it is about the technology itself. Some of it is about making sure that we've got the capacity and the systems within there. Some of it's also about making sure that people are comfortable using it, and we have been trialling that. And tangential matter, I have been to see situations such as in Barlinnie, where people are are appearing before the sheriff in the custody court without having to be taken in a van from prison to court and quite often back again. So these things are moving. We would like it to move faster, but I can give you an assurance that moving they are.
I just want a point of clarification. It maybe is a sneaky supplementary, but you've slipped in there peripatetic courts. And I just want clarification that this isn't just evidence taking in places, but it will be as a court. And that you also mentioned children's welfare hearings, but perhaps vulnerable adults in discussion with the SCS. Have I got it clear? No. This isn't just taking evidence like at a bedside or in the field or whatever you have to do, but actually as a court.
Yeah, absolutely. When I appeared in Dundee Sheriff Court, and we'd be back in the 90s, the hearing would take place within the reporters' offices. It was a hearing because the grounds of referral were not accepted by the child, and there had to be a proof to hear that. That, as I say, is what the court service are looking to consider elsewhere, not simply in Dundee. So it's not simply evidence on commission, it would be the totality of the proceedings in an environment that is more suited, as I say, certainly initially in children's matters, but also I think the court service is expressing a witness as law changes and we deal with vulnerable adults as well as vulnerable children. There may be better places than courts.
Sheriff Drummond said you needed legislation for that. Was he wrong?
My understanding is that we don't for the matters such as this, but that's a matter, if we require legislation, we will address it. Okay. I'm not aware of the legislation that provides for it in Dundee and would restrict it elsewhere. So I'd imagine it would probably depend upon the nature of the hearing, but certainly the court service is seeking to work with SCRA to ensure that we work this out, and if legislation is required, it will be provided. But something has been done somewhere along the line, because it was when I appeared, and I've not practised law since 1999, it's still the situation in Dundee.
Thank you. Sorry, Sandra, I didn't know if you were going to ask that.
But it was similar to your own follow-up.
Just to follow what Sheriff Drummond had said. Okay. Right. Oh, right. Alison McKinnon. please.
Thank you very much. Good morning, Cabinet Secretary. Many of the people who corresponded with the Scottish Court Service at the initial consultation raised, I think, very genuine concerns about the dangers of centralisation of our justice system, and I think they understood that the value of local courts goes beyond the bricks and mortars. What weight do you give to access to and the visibility of justice locally in our towns and communities around Scotland?
Well, it's obviously very important. It's not just the individual matters that have been referred to by yourself, but organisations such as Citizens Advice, and I was speaking to one of their legal advisors on Saturday, make that point. That's why when the Scottish Court Service considered this, they looked at this, they factored it in. We are talking about distances of, in the main, less than 20 miles. We're not talking about people having to go 200 miles or more. So I don't underestimate challenges in some particular matters, but we're talking about a small number and we're talking about a limited distance. So the point remains that, yes, we do want to keep it local, but equally, we do accept that law has changed. It's much more specialist. It's not just civil and criminal. We have adults with incapacity, we have mental health, we have children. People expect commercial matters, they expect reparation matters, they expect areas, whether it's adoption or other things. You do have to have some element of some specialisation, and that can sometimes come about by ensuring that that level of specialisation can be provided for where you've got a critical mass and number of sheriffs, which is why at some moments, some matters already, matters get directed to particular courts because that's where they have to be done.
It might only be a matter of 10 or 12, 15 miles on a map, but you're removing local justice within small rural towns and villages and making people travel to cities. So in my own area, for example, Stonehaven, a county town for a long time, now being kind of demoted to people travelling to that. Do you understand that justice being seen to be done in your own community is an important part of the justice system?
Yes, it is, and these points were made to me when I met with some people from Rothsay. I can understand that, you know, sometimes naming and shaming. That's why courts are public buildings, except in very limited circumstances, because it's a public opprobrium that's delivered by the sheriff. And it is important sometimes that these matters should be dealt with and also aired, whether in the local paper or others. But I do believe that given the limited distance, the difficulties for the local press can be overcome. Nobody is going into this with any relish or zealousness. These are matters that challenge all areas of civil life. The cuts are sometimes, and to be fair to Mr. Lamont, they don't always come from the government. I was sitting just last week with the Church of Scotland in an area of my constituency as they look to go from 3 churches to 1. It's all very sad, but I fully support them. Is it the right thing to do? Yep. Is it driven by changes? Definitely. That's the world in which we live. People will have to go further to get to their church, but that's the world.
Okay. Turning to the needs of children and young people, Scotland's Commissioner for Children and Young People has said, overall I regard many of these proposals as having a potentially detrimental effect on children and young people. And I looked at the Scottish Court Service's Equality Impact Assessment, and I have to say it gives cursory attention to that. What consideration did you give to the particular needs of children and young people, particularly vulnerable children, in advance of taking this decision?
Well, that's, for example, why we've been mentioning, I think, the position being taken by the Scottish Court Service on the hearing and, of grounds of referral, I think is an excellent proposal. I always thought when I practiced law that the situation in Dundee was much better than in Edinburgh. When the grounds of referral, why are you taking people in mixing with more serious criminals? Because quite often it would be matters where they're on a trajectory of offending. So I welcome the action being taken there. I also think that the views on vulnerable people are well represented by Capability Scotland, because it's not just children, it's adults, and I think they welcome the benefits that will go in actually having court buildings that are able routinely to provide provide this. And thirdly, when you're not going to the building, we have the assurance and guarantee by the Scottish Court Service that those video links are now being provided in areas. So as I say, we are where we are in terms of the financial challenges we face, but from this we will provide a court system that has the specialist expertise in terms of what's required on the Shrieval bench in many more areas. We will be able to provide the video linking in many instances that wasn't there but will be capable of providing, and the facilities in which vulnerable people have to go to and give evidence in what is a challenging matter will be better.
With respect, Cabinet Secretary, what you've mentioned this morning is all very ad hoc, that you hope certain things will happen and some things might happen. Would it not be much more sensible to ensure that all of those good ideas that you have that are going to help things are in place before we close the courts?
Well, I think I did say the video linking there coming in June. We are now in June. The briefing actually came to me before that, but you know, it's coming this month. It's not here necessarily today, but it will be in this month. The buildings to which courts are business is being moved are better and provide for that. They are already established, which is why Edinburgh does the jury trials for those that were currently taking place elsewhere. So I think I can give assurance that is there. And as I say, the other matters such as SCRA and indeed where and what might happen with adults with incapacity or whatever are things that I welcome the action being taken by the court service. So some is work in progress, some is shortly to be delivered. And yes, I think you do make a fair point though that some, yes, we have to probably just make sure we keep our foot to the accelerator.
We could be provided with the details, if you have the details, where video linking will be placed prior to any proposed court closures, which I think start next year. Is that right?
We will get that information to you.
It'd be grand if we could have it before next week, if that's possible, before debate.
It will be possible. Yeah.
I think that'd be useful, so we have some details and specifics. Sorry,
thank you.
Just,
thank you. You mentioned earlier the European directive. I think both yourself and I were at Victim Support Europe conference last week, so you'll be up to speed on that. One of the issues round about protecting victims and their family members is Article 18, which requires measures that are available to protect victims and their family members from secondary and repeat victimisation and from intimidation. Many of the people who have corresponded with us have raised concerns about the extra travel, the particular impact on the vulnerable witnesses in rural areas where they will have to travel on the same buses back and forward to court and therefore are actually more exposed to the possibility of secondary and repeat victimisation. How do you respond to that?
Well, I think you're right to raise those concerns. They are legitimate and understandable concerns, but they are matters that are and have been and will be dealt with by the Crown Office and Procurator Fiscal Service. Most of the issues there relate to criminal matters. They are dealt with by the Crown at the present moment, and they have given a clear assurance that they will make arrangements, sometimes particular special arrangements, sometimes more general arrangements, but they will take that in, and there is a clear assurance that any victim who worries, either individually or through Victim Support Scotland, will be able to engage with them. I think in most instances the point you make, which I accept as a fair one, is a matter more for the Crown and the Scottish Court Service, but we have engaged and liaised with them and they have given us those assurances.
Okay, thank you. And if I might just turn to my two local courts, which are Stonehaven and Arbroath, both of them efficient courts, both of them with space to do business properly, are being sent to receiving courts. In Stonehaven's particular regard, a court that will take it to 97% capacity. Do you consider that sensible?
Well, as I say, the Scottish Court Service has looked at matters. There are matters that they've taken into account and they are satisfied, and I am satisfied, having looked at the information, spoken to matters that it's capable of being dealt with, that the capacity is there, but they've taken this into account. Never mind the fact that in many instances, in particular, people are working in those areas rather than perhaps in the place in which they reside. But these matters have been factored in and the capacity is there.
And you said earlier that many of the courts that you're closing don't provide properly for vulnerable witnesses. Arbroath has a very good support network, so not only does the court provide for vulnerable witnesses, but nearby there are victim support and women's aid. Those facilities are not available in Forfar.
Well, I mean, I know Arbroath meets some matters having appeared in it, but Forfar is capable of meeting all the requirements there in terms of accessibility, and therefore the decision has been made that Arbroath is Forfar is a better venue. There are factors that have been made by yourself, understandably and correctly. They've been made by Graham Day and Mike Weir, but we've worked with the Crown to make sure that we deal with those coming from remoter parts of Angus that have to go to Forfar as opposed to Arbroath. And equally, as I say, the court in Forfar is perfectly capable of dealing with the capacity issues.
I'm just going to let people know where they are on the list. And if you can remember, fine. If you can't, write it down. I've got Chick Brodie, Margaret McDougall, Lewis MacDonald, Roderick Campbell and Colin Keir. You're not forgotten, and I've not fiddled the list. That's the list as it's been from the start. Do you want in Nigel? Is that you indicating as well?
Yeah, I'll go tail in.
You don't have to. Don't feel compelled, but there we are.
Gunner,
Chick Brodie, Forfar, Margaret McDougall. So you know where you are on the list. Right.
Thank you, Convener. Good morning, Cabinet Secretary.
Morning.
Thank you, Convener and members of the committee for affording me the courtesy of being allowed to ask a couple of questions. Cabinet Secretary, you're aware that the report by the court service in the case of Haddington was disputed, and the dispute was presented in the form of a forensic analysis prepared by an independent accountant. In that report, which confirmed the annual cost savings in Haddington was 81,000, but of that, £34,000 was depreciation, and I understand the £47,000 of revenue expenditure may now be covered by East Lothian Council. The issue, however, is the capital saving of £471,000 from the maintenance budget. It's my understanding that only 5 years ago there were virtually no dilapidations required. And I just wonder, following on from Graham Pearson's question, wouldn't it have been better to have had quite clear engagement and definition as to how these numbers were arrived at, so that we would have avoided the dispute that we currently have?
Well, there is a dispute, and there was a report provided by a forensic accountant. Equally, as I say, I did clarify various matters in response to Ian Gray's question as to how the Scottish Court Service disputed those figures, and I stand by that. I have to say I'm not qualified architecturally to be able to comment, but I think we all are aware that many buildings in Scotland do face, because of climatic changes, significant issues over recent years. But it is quite clear, and I don't think it's disputed by anyone, that the maintenance backlog is approaching £500,000 and remains outstanding. Why that has been, I don't know.
This morning on the radio, a gentleman from the Law Society said, in terms of the total court service, the backlog of maintenance arrears was 53 million. How could that be? That's over many years. How could we get to that situation?
Well, I think what you'll find is that many of our courts are Victorian. Some, such as Selkirk, have been presided over by Sir Walter Scott. They provide great history, and they provide a great landmark in our communities. But equally, they come with challenges in the modern world, not simply in terms of care and maintenance to the fabric with the climate that we face. Equally, they come in challenges with providing the facilities, and indeed whether that's physical facilities or whether it's technological facilities.
Okay, thank you. One last question, if I may, Convener. In the background to this report that was received, the Lord President was quoted as saying that radical changes are imminent in the provision of both civil and criminal justice. This exercise has been carried out, and we all know that how heavy the cost reductions have to be, but was this an isolated look by the SCS at one particular area, or do you believe that they've looked at the efficiency across the whole of the service, from top to bottom?
Oh, absolutely, and that's why they viewed some courts as sacrosanct. whatever savings and costs there may be, we do recognise, and they, I think, to their credit, recognise that Kirkwall, Lerwick, Stornoway, Lochmaddy are island communities that have to be dealt with. Ross is somewhat different because of its proximity, but as I say, I think they've looked at Scotland geographically. They've accepted the situation that you cannot have, for example, a situation where there's no court between Wick and Inverness, which is why they have retained Tain. So I think I can give you an absolute assurance that they've looked at this holistically. They've looked at it pan-Scotland. They do face significant challenges because investment was not being made in years past, prior to either the Lord President, the Chief Executive, or even myself being in situ, and we do have buildings that are lovely to look at but cost a fortune to maintain.
But there are other areas of revenue expenditure. I mean, how, and I know very little, so forgive my naivety, how do you measure the efficiency of the senior members of the Scottish Court Services and those that dispense justice?
I think we're slightly wandering off this topic in that we're going to the court service against, and I realise you extended it into a holistic approach, but I think that would be into an area I don't want to, I think, is part of this questioning session, Mr. Brodie. A good try. Margaret McDougall, followed by Lewis MacDonald.
Thank you, Convener, and good morning, Cabinet Secretary and panel. I really want to ask a question on costs. I have before me a letter to Christine Graham, the Convener, from Catherine Dyer, Crown Agent and Chief Executive. And in the costs, she states that the likely cost for Sheriff and Justice of the Peace Courts for additional costs for witness travel would be 15,000. Additional costs for higher courts would be 16,600. And the relocation costs of staff would be 24,000, which adds up to 55,600. And the savings would be on buildings of 46,332. I just wonder, you know, how can you justify that? And also, within the letter, she also states that all of these costs can be met from within existing budgets. So if we can do all this within existing budgets, why are we looking to these closures and savings?
Well, Catherine Dyer is an outstanding official and representative, but she's an official and representative of the Crown Office and Procurator Fiscal Service. She's looking at matters and making comments relating to the implications for the Crown Office and the Procurator Fiscal Service, more importantly, locally there. That's why, going back to my statement at the beginning, this matter is driven by a position taken by the Lord President and the Chief Executive of the Scottish Court Service. It does have implications across portfolio that we're obliged to look at as a government, how it impacts upon Crown, how it impacts upon police, how it impacts upon victims and witnesses. So there are matters, but holistically we have looked at matters and recognised that there are issues and challenges for the Crown. But as Catherine Dyer has said in her statement, it's a matter that they are perfectly capable of addressing. And indeed, it would be fair to say that the Crown Office has gone further and faster than the Scottish Court Service in moving into a regional model of east, west and north, and making sure that matters are dealt with in a pyramid structure, which to some extent is, I think, where the Lord President wishes to take the court service.
If we could just turn to the local matter where Irvine Justice of the Peace Court is to be closed, and the business will then be taken to Kilmarnock. I mean, there has been a lot of concerns raised regarding the travel costs and the implications for a quite deprived area in North Ayrshire, you know, where you have people from the likes of Ardrossan, Saltcoats, Bede, Rye, having then to travel to Kilmarnock, which will be an additional cost and perhaps impact on their attendance, given the bus services are being reduced. But so I just wonder what the comments you have to say on that.
Well, that's a matter discussed with David O'Neill, the leader of COSLA, but it was him that made the point to me that there isn't a court in North Ayrshire, and he actually couldn't understand some of the issues that were coming up with it because he didn't represent that area, but I have a highest regard for him. So there are currently areas where there are no courts. There is no court in East Kilbride. There is no court in Glenrothes. Some of these things are historical. The Scottish Borders has 4 courts because we had Peeblesshire, Roxburghshire, Selkirkshire, and so on. So these things are matters in which change, and I know Mr Gray has disputed it, but I grew up in Linlithgow. It had its Sheriff Court. It has moved to Livingston because the population has moved. Linlithgow is no longer the county town. It's a lovely place, and I met many friends on Sunday at the Junior Cup final. But business comes out of Livingston. So I think some of these things are just the way of the world, and we have to recognise that sometimes the court service also has to take cognizance of where the business is, where people are coming from. They do face challenges. Many of the points you make, I do accept there will be issues and people will have to go that bit further to get to Kilmarnock. But it is matters that are less than 20 miles. There are matters in which they're probably doing it anyway. And as I say, I can give you an assurance that the Crown Office, as well as the court service, are taking that into account.
I'm glad you raised about David O'Neill, because you did raise this same statement in the Chamber a few weeks ago. And I spoke to David O'Neill on that regard, and he said that he may have said we don't have a Sheriff Court in North Ayrshire, which is true. But when he was leader of North Ayrshire Council and administration, he was working with the SNP councillors, lobbying to get a Sheriff Court in North Ayrshire. So I just wondered if you could clarify that.
There may be, and ultimately the Scottish Court Service may consider that, but that's part of looking, as I say, at a justice centre, for example, in Galashiels, that I do think would be of benefit to the borders in terms of being the point where buses and indeed ultimately the train will go into.
I'm getting a world tour here of various courts and so on, and the Cabinet Secretary doesn't have to get about and at football matches. I'm not surprised you've got time for it. Now, Lewis MacDonald, followed by Roderick Campbell.
Thank you very much, Convener. And Cabinet Secretary, you said at the beginning it was important to avoid silos, and when the Court Service's findings were announced on the 16th of April, I asked you whether you would consider the economic impact on county towns of court closures before reaching a decision. And you said that you would. And then at the beginning of May, you responded to my colleague Richard Baker and said that a proper assessment of economic impact had been made before a decision was reached. Can you tell us who made that assessment and whether it will now be published?
Well, I make the assessment myself on the basis of the information that comes before me from the Scottish Court Service. I think your question is predicated to some extent also on the points that I listened, I think, with some incredulity on the radio, that the savings could all be made by simply improving fine collection. Let me first of all indicate, to build upon the Chamber, that the SCS is having increasing success. 86% of the value of Sheriff Court fines imposed between April 2009 and 31st March 2012 has either been paid or is in track to be paid through instalments and the measures we put in. What I am incredulous about is that it is not possible to fund justice services from fine incomes, as most of this income goes straight to the Treasury south of the border, who are imposing the cuts. These are devolution arrangements that came in the Scotland Act 1998. These are arrangements that you have represented a Labour government in this Parliament on. You know as well as I do that the fine income paid in Scottish Sheriff Courts in the main went to Alistair Darling or goes to George Osborne. And to suggest that I am able to get it to reduce and minimise the cuts being imposed by the Coalition is frankly incredulous.
I think, Cabinet Secretary, when you start talking about Westminster matters, we have to suspect that you're on shaky grounds on the matters for which you are responsible. Are you telling us that there has been no economic impact assessment done by anybody on these court closure proposals?
Well, there have been matters, Dest, in terms of how we look across the board. All I was pointing out, Mr MacDonald, is that your suggestion was that all this could be sorted out if we simply took fine income that was outstanding, which is at 86% collection
with the greatest
rate,
respect,
and that
Mr.
would
McCaskill,
pay off matters. What I'm saying is that is not possible, because the money goes directly to south of the border, and therefore we're not able to do it. With regard to the economic analysis, the Scottish Government's business and regulatory impact assessment was developed in conjunction with the Scottish Government's economists, and it concurs with the economic impact assessment carried out by the Scottish Court Service.
Well, I'm glad you got to that. And of course, I too listened to the radio, and I noticed that you chose not to answer questions yourself on the radio this morning on these matters. I'm glad you finally got to the point. So there is an economic regulatory impact assessment. Will you now publish that?
It was submitted with the draft orders. And
so where is it now?
I think maybe you should check your papers.
Is it in the public domain, is it?
It was
clarify, Mr. Stewart, sorry.
It was submitted with the draft orders. So,
it's with, you see, unfortunately, Mr. MacDonald's not, I don't mean unfortunately, I don't know what I mean there, but you're not on the committee, so the committee has that information.
That's very helpful. If it is indeed the papers that I have seen, clearly they are matters of a very shallow and superficial examination. And I wonder in light of Mr. McCaskill's commitment to discuss these matters with Cabinet colleagues, whether he has now done so, and in particular whether he has discussed with them the proportionality of the closures and their impact on local communities with the level of savings which he proposes will be made.
Yes, I've discussed this matter with Cabinet colleagues.
And can he tell us, for example, in relation to Mr. Russell's publicly expressed concern that the level of savings here is not proportionate? I think he described it as very small savings anticipated, which should be seen in the light of a further rundown of these normal activities in all other similarly sized Scottish communities. Does he now believe that Mr. Russell accepts that there is no impact on justice in the communities which he represents?
Well, I met with Mr. Russell, who brought in a delegation from Rothesay, including those who appeared in the court, those who represented newspapers. As I said to Alison McInnes, I thought some fair points were made regarding the requirement for some public opprobrium, not simply that dispensed by the bench, but dispensed in local papers. And I think that we can work through that. But I think that's a matter you need to ask Mr. Russell. What I can say, I was delighted to engage with him as he sought to represent his constituency and bring them in.
That's helpful. Can I ask you one matter for which you are directly responsible, which is the intentions of the Scottish Court Service and the suggestion made by Eric McQueen 2 weeks ago that feasibility studies will be undertaken, which could indeed lead to a further round of closures of courts after this closure, if indeed that round of closures goes through?
Well, I think the Scottish Court Service keeps matters constantly under review, and indeed we've just heard from Margaret McDougall a proposal that perhaps there should be a court in North Ayrshire. It's not for me to comment, and I don't know whether that matter's been given any credence by the Scottish Court Service or not. I do think there's a recognition that justice centres, and I think that's what was being referred to by Eric McQueen, and in particular justice centre in the Borders, because it does seem to me that exactly the same as in West Lothian, we recognised that the population lived in Livingston and Greater Livingston. That was where the needs and requirement was, that it would be better to provide for a matter that could deal with a whole array of matters and co-locate. It would be better to move it from the lovely but historic building that Linlithgow Sheriff Court was, that I also appeared as an agent in, and go there. So these matters are kept under review. Whether it will be North Ayrshire or whether it will be Galashiels, that will be a matter for Mr McQueen, but I can give you a clear assurance that these are matters that we engage with elected members and local authorities, and indeed, obviously, any further proposals would require to come back here.
Mr McCaskill, you compared, in answer to a question from Ian Gray, you compared the closure of sheriff courts in some of Scotland's towns with capital punishment and the stocks as things that were antiquated and needed to be reformed. I think we all, or at least you and I may be old enough, many other committees members will not. You and I, Mr McCaskill, may be old enough to remember the government which abolished capital punishment. Can I ask you, will you be proud to be remembered as the Cabinet, the Justice Secretary who closed so many sheriff courts across Scotland?
I think I'll be proud to be remembered as the Cabinet Secretary for Justice that stood up for Scotland in the face of huge budget implications, that has delivered a 37-year low on recorded crime and indeed has presided over a record number of police officers patrolling the communities of Scotland, keeping us safe and secure.
To say that is love all, I think, at that stage. I'm not sure. Can I just say the Justice Papers, in fact, although I said you're not on the committee, they are in fact in the public domain. So if anyone wants to see the economic impact assessments, they'll be there with the draft orders. Now, I don't want to curtail people. Please don't think I'm doing that. But the short questions would be useful as we've got Lord Gill waiting as well. And I want to give you a 10-minute break or an 8-minute break. Roderick Campbell, it's getting shorter all the time. Roderick Campbell, Colin Keir, Nigel Dawn.
Morning, Cabinet Secretary. I was pleased to hear your remarks in relation to the use of premises other than courts for judicial matters. But following on from what Sheriff Drummond said last week, he said that he could see no body of principles or policy formula against which we can measure these proposals with regard to the provision of rural justice. James Wolfe also said where applicable in areas of rural mainland Scotland, sheriffs rather than people should travel. And I think that view was also endorsed by Stuart Naismith of the Law Society. And indeed, Lauren Wood of CAS, talking about the potential next level down of summary sheriffs, talked about the possibility of peripatetic summary sheriffs and specialists. Are there any thoughts of the government in relation to these areas that you could share with us?
Well, I think I mentioned it earlier. I think having discussed these matters with Eric McQueen, there are some matters in criminal proceedings. I just think that is just not possible. Security, safety, all of these matters cannot do it. Some courts, for example, that are closing don't have appropriate cell facilities. That is not something that we can countenance. Equally, I do welcome the sensible position I remembered as a historical matter in Dundee Sheriff Court, and I'm delighted that that's being looked at across the board and was, in fact, in train long before I spoke to Eric McQueen about it. And I welcome also the initiative as we look at new areas of law, especially dealing, for example, with adults with incapacity. Courts were made in a time when you were dealing with civil and with criminal, when civil probably meant not even a divorce, because at the time many of these courts were built, divorce was dealt with in the Court of Session. So you were dealing with litigation claims, whether over a horse or farming stock or a road traffic accident, and you dealt with criminal matters. The world is more complex now. Our courts do require to deal with adults with incapacity, as well as adoption, as well as mental health matters, as well as commercial, as well as bankruptcy. Some, but not all, will be suitable for being looked at, and I can give you an assurance that the court service will look at that. Some will always have to be dealt with because of the nature, the security risks, the specialists that will require to go with it. But we are in a new world with technology. Video linking will change matters, and I think what I can say to you as a government, we're willing to look at all these matters, but we will be driven by the clear advice that comes from the Lord President and those who serve under him in the administrative capacity, either as the Chief Executive or as Sheriff Clerks.
Thank you for that. On a slightly separate matter, obviously, I am still a member of the Faculty of Advocates, and I should declare an interest there. You referred to the fact that you were a practising lawyer. I think it's longer as 1999 since you last practiced. From the point of view of solicitors firms in towns which are going to be affected by these closures, in my own constituency, to be a wee bit parochial, I'm not aware that any of the leading criminal firms have an office in Dundee, and if they do summary legal aid work, they won't be paid for travelling. What kind of advice would you, as the Cabinet Secretary, give to these firms of solicitors faced with these kind of issues?
Well, I mean, I think what you'll find is, as with Peterkin and Kidd and other firms that existed in Linlithgow, the world changes and they continue to provide the service simply in a different location. Equally, many of them that are doing, for example, specialist criminal matters will probably find that they're doing more business in the busier court, that you would be doing probably more criminal representation in Dundee because you're more likely to have people who are appearing there. Because many of these matters, I think, as are correctly pointed out by the Crown, it doesn't mean that just because an offence happens in a jurisdiction that the people necessarily come from there. Significant numbers of people who appear in Kirkcudbright Sheriff Court are not people from Kirkcudbright who have committed any offence, because it's a remarkably law-abiding area. It's quite often people who have got off a ferry at Cairnryan and are heading for the M74 and the M6 and they commit a road traffic offence. So sometimes you'll find that from these changes, people will ironically be in a more local court because they've actually been travelling.
Okay, I'll leave it there, Christine.
Colin Keir.
Okay, thank you, and good morning, Cabinet Secretary. My question is really about the movement of some cases from the Court of Session and some concerns that have been brought forward about the ability for these cases to be heard in a full and proper manner. Could you give us some of your comments on that, please?
Well, you know, there was a decrease in 2012 on the previous year of 6%, and there's been, in terms of criminal business, we're 19% down from the peak in 2006-7 in terms of criminal business. In terms of civil law, there's a drop of 35%. So business has fallen in our courts, which is why there is capacity in these buildings. You're right to indicate that the Court Reform-Scotland-Bill proposes to move some cases from the Court of Session down to the Sheriff Courts. There will be, as I say, a specialist Sheriff Injuries Court, and the clear information from the Scottish Court Service is that the volume being transferred is perfectly capable of being taken up and soaked up. So as I say, we've got declining business, both civil and criminal, and although increased business will be generated in a downward push from the Supreme Courts, it's all capable of being addressed and has been number crunched.
Nigel Dawn, and you'll be the last question. And I know I've said that, and you usually put your hands up, but it is the last question. Nigel Dawn.
Thank you very much, Convener, and good morning, Cabinet Secretary. Can I start by saying that I, as a local member, have no interest in seeing Stonehaven Court closed, but I am now at least reassured that the business can be transferred to Aberdeen without that being as overwhelmed as it might be suggested. And if I can just briefly pick up on the number that of 97%, which Alison McInnes mentioned earlier, that's a number that I actually put in print, but unfortunately derives from the court service giving us every day as a full day when actually they're fractional days, and I'm quite clear now that there is considerable capacity left in Aberdeen. Indeed, if we put Aberdeen and Stonehaven business together in the last year, it's less than it was the year before. In Aberdeen alone. So I'm quite happy about that. I'm wondering if I might pick up, firstly, on the issue of transport to courts, please. I'm particularly concerned in that regard with Forfar in the south end of my constituency, where it's much more difficult to get to Forfar than it is to Arbroath. And I'm secondly wondering whether I could pick up on the issue which has already been mentioned about alternatives to using the courts and recognising that civil work might well be done outside a court in a more local venue, and whether we actually feel, or whether you feel, that there is actually the capacity to bring some of the business, the local business, particularly the civil business, back into the community through other routes, because I think people don't want to travel to the city to deal with the local thing if it can be dealt with locally in a hall.
Well, I fully understand where you come from, and I think the points have been made by you to me both today and before, as indeed it's been by Mike Weir and others. There are specific issues, I think, in some geographical matters there. They're matters that the Crown will look at, will work with, and indeed the court service will also take that into account in terms of those who are coming from more distant parts that will have to go to Forfar, who would have been routed into Arbroath, and I know the geography of the Mearns will have some challenges. So I can give you an assurance that both the Scottish Court Service and indeed the Crown and Procurator Fiscal Service will take that into account and will work with you and others and the particular individuals concerned. In terms of the local aspect, I think it comes back to the point I made earlier. There are some things that will always have to be dealt with in that manner. Equally, as we move towards summary sheriffs, as we move towards the change through the the Court Reform Bill, then I think you'll see us move towards a more pyramid structure that will see a lot more dealt with down more locally, that will be dealt with a lot more quickly and efficiently. This is about getting some of the landscape in terms of the buildings right, but the intention of the court service, the clear direction of the Lord President, is to make sure those at the very top are dealing with the specialist cases that they have the talent, intellectual capacity to deal with. Other matters are dealt with more locally, but the specialisations that's necessary in terms of domestic violence are there and are not simply dealt with by somebody who's well-meaning but not being properly trained. In terms of matters going out. I think we have to look at technology for some aspects, but it takes on board the point made regarding children's hearings, what may happen in terms of adults with incapacity, where there are clear matters, where if you were starting from scratch, you would not probably put into court somebody who's been involved with child abuse and at the same time in a different room, and sometimes in some smaller courts in the same room, but at a different time or on, thankfully, on a different day, somebody who goes in to adopt a child that's the greatest day in their lives. That's unfortunately the landscape that we have inherited because of the court buildings that we have, the court system. The court service is, I can give you an assurance, trying to work as best it can to provide for all the new challenges, to change for matters, and at the end of the day, I can give you also absolute assurance it's about providing for the care and benefit of those who require to be there because they're victims and witnesses, because it's not just court closures that we're dealing with, it's not just court reform that we're dealing with, we're also bringing in the Victims and Witnesses Bill because we do recognise the challenges for those who have suffered, who do require to do their citizenly duty and are entitled to get a standard and be treated with dignity and respect.
I think that's been a very long session. I thank the Cabinet Secretary and indeed committee members and members for the manner in which we've asked these questions. I'm going to suspend for 8 minutes. That's quite good actually, 8 minutes. And then we move on to the next panel. Thank you very much. We're back reconvening, and I welcome our next panel of witnesses to the meeting, the Right Honourable Lord Gill, Lord President of the Court of Session, Eric McQueen, Chief Executive of the Scottish Court Service, and Catherine McGregor, Legal Secretary to the Lord President. I thank you very much for your waiting, slightly delayed. It was quite a long session, but I know that you were able to hear that evidence session. And, Lord President, you wish to make a short opening statement.
Yes, thank you very much, Convener. Thank you for inviting me to this session. I hope I can make a useful contribution to your committee's deliberations. I think that what you're really looking for from me today is some statement of the main principles that underlie the High Court and Sheriff and Jury reforms. So perhaps I could start with that, if I may. What I really want to do is just give you the general policy framework that has led to these proposals. On the detailed statistical and financial questions, I would defer to the Chief Executive, Eric McQueen, who has got all that information at his fingertips. But I'd like to make some general points. The background to all of this is, I think, important, and that is that Scottish Court Service, whether it likes it or not, has to achieve a reduction in its budget of 20% over the 4-year period from 2010, 2011 to 2014, 2015. We've got no choice in the matter. That simply has to be done. And 40% of our running costs at the moment are tied up in the buildings forming the court estate and the very considerable cost of upkeep and maintenance of those. So that, I think, helps to set the scene. That has necessitated that we should take a fresh look at the distribution of court provision in Scotland and see if there are ways in which it can be streamlined, made more efficient, and at the same time achieve the economies that we have to achieve. And as we see it, the way forward is to have dedicated high court centres in Glasgow, Edinburgh and Aberdeen, but with additional high court capacity in other designated sheriff courts whenever that additional capacity is needed. And as a sort of long stop, we propose that there should be an opportunity for high court sittings, not in the 3 main centres or even in the satellite designated courts, but in any other court if I or the Lord Advocate should consider that to be in the interest of justice. So there is quite a bit of flexibility in these proposals, and we would propose that these changes are phased in the period from now until 2015. I think there is a recognition now that the days of the circuit approach to High Court justice have really passed into history now, and 80% of the High Court trials in Scotland at present are being conducted in the 3 centres of Glasgow, Edinburgh and Aberdeen. And of the remainder of those cases, only about half can be said to be cases that are local to the courts in which they are heard. There is a considerable opportunity here for better case management and more flexibility and efficiency in the disposal of business in 2 ways. The first is that by having these dedicated centres, there's less downtime if trials go off or trials finish prematurely. Then instead of the court simply stopping for the day and coming back when the next trial is programmed, we can have a running programme in these courts which will mean that there will be no gaps such as there are at the moment. The other thing is that by moving away from the circuit system, we reduce the intrusion which the High Court makes into the Sheriff Court, because, of course, as you know, in the days when the High Court went on circuit, other than in Glasgow, it sat in the local sheriff courts. Places like Stirling Sheriff Court, Dumfries, Oban, Ayr. That constituted quite an intrusion into the work of the Sheriff Court, because it meant that during those weeks the Sheriff Court could not operate to full capacity. So there'll be a very considerable improvement in that regard. That, I think, is all I would wish to say about the planned approach on the High Court side. If I could just say a word, please, about the provision for sheriff and jury trials, because, of course, there are many more jury trials conducted in the Sheriff Court. The idea now is that we should have 16 dedicated sheriff courts which will handle the sheriff and jury trial business. And at the moment, these 16 courts are accounting for about 86% of the caseload anyhow. So it's not really all that revolutionary to dedicate these courts as sheriff and jury courts. And over time, my hope would be that these courts would become centres of specialisation in that particular form of criminal litigation. But in addition to that, for flexibility, we propose that other sheriff courts can be used for sheriff and jury trials wherever the sheriff principal considers that it's in the interests of justice that should be done. And then the outlying courts like Lerwick, Kirkwall, Stornoway, Lochmaddy and Portree, they would remain as courts of universal sheriff jurisdiction to hear all Shrieval business. I mean, that's just a matter of practicality. And the plan is to phase this proposal in over a 10-year period. I think you'll agree that this is a fairly flexible model that we're proposing. There always will be cases that will be appropriate for the smaller sheriff courts, and these proposals don't rule out the use of those courts for sheriff and jury trial. The plan is to give the sheriff principals a discretion in the matter, because they know basically what the local conditions and the local needs are. But speaking generally, I would expect to see almost all of the sheriff and jury work eventually coalesce in these 16 centres. So that's the proposal, and I'm very happy to deal with any questions that you may have in relation to that.
Take John Lamont, please. And I know that this will be a less robust session, perhaps, than the Cabinet Secretary.
Thank you,
Or
Convener.
perhaps not, John. We'll
I'll be my best behaviour. Good morning. Can I...
Secretary's grilling, I'm absolutely terrified.
I'm sure no.
Can I refer you to the Court Services Principles for Provision of Access to Justice, paragraph E, which says the Court Service should ensure that more people will be able to travel to the local court by public transport so as to arrive at the start of the case in which they are concerned and be able to return home by public transport on the same day. Now, 2 weeks ago, when we heard from Mr McQueen and his colleagues, it was very clear that there is at least the possibility of somebody travelling from, say, for example, Eyemouth in my constituency to Jedburgh Court will have some difficulty using public transport, and indeed it was foreseen that there may be the need to stay overnight to ensure that they're there on time. So do you accept that these proposals will therefore cut across that principle of your own document?
No, I don't. I think it's rather unhelpful to assume that because a case comes from Eyemouth, let's say if a crime is committed there, that the witnesses will necessarily come from Eyemouth too. I mean, even under the present situation, you have witnesses who have to travel considerable distances to courts just because they happen to be caught up in a particular incident in a particular place. Our best estimate is that the effects of these changes should be fairly neutral. I mean, at the moment there are these difficulties. All I can say to you is that there are difficulties in certain areas in public transport, and we recognise that. But this is against a background of much wider access to cars than in the past. I think that's probably as much as I can say on that. You know,
with the greatest respect,
these problems are perennial.
I mean, with the greatest respect, that's a very metropolitan outlook on life. In areas that, in my constituency, I mean, there is a real issue with public transport, and these changes, at the very least, will make matters much, much worse. And I just want to know whether you accept that, yes, it's not ideal just now, but these proposals will significantly deteriorate matters.
I acknowledge that there are these difficulties. I'm not dissembling about that, but all I'm saying to you is that these difficulties exist at the present time. I don't see that this is going to make matters any worse.
Are these
not
changes
necessarily? It may in individual cases, I accept that.
Are these changes about saving money or about delivering a better justice system for Scotland?
Well, the impetus for all of this arose from the need to save money, as I've explained to you. But in actual fact, one of the outcomes of the cost constraints that we're suffering from has been to make us question certain assumptions that we would have continued to make in more prosperous times. And once you find yourself having to take a long, hard look at the existing system, you do find that certain weaknesses that you have not noticed over the years become quite obvious and apparent. My own feeling is that a perfectly good intellectual case could be made for these changes, even if we weren't living in these rather unusual economic circumstances. There is a good case to be made in a modern Scotland for having centres of specialisation and excellence, and for making the most efficient use of resources that you can. And if you were to sit down today and plan a justice system for Scotland based upon a network of high courts and sheriff courts, it would be nothing like the present pattern. The present pattern is really based on a Victorian model, and down through the years that has been recognised. When I was a young counsel, I appeared in Dunblane Sheriff Court, I appeared in Nairn Sheriff Court, I appeared in Kinross Sheriff Court. All of these places have passed into history because it was recognised that they were simply underperforming.
Well, related to that then is the issue about justice centres, and from my own constituency's perspective in the Borders, there was the suggestion that the remaining courts would close with a justice centre opening in Galashiels, and there was the suggestion that this would also apply to the Borders, Fife, Lanarkshire and the Highlands. Now they don't correspond to the boundaries of existing sheriffdoms, and I just wondered if you could clarify which areas are under consideration for having these law centres created.
This proposal that I'm speaking to today does not involve the creation of justice centres. However, in the consultation paper that we issued last year, the question of establishing justice centres was foreshadowed. The Scottish Court Service Board has got no concluded policy decision on that matter. There has been no decision made by the board to establish these centres. But if you're asking me for my own view is that it's an idea that is well worth exploring. And I think we ought to look into it and see just what the advantages could be and also what the disadvantages would be. And I would expect that over the next year or two, the Scottish Court Service Board will turn its mind to that and see if there is any if there is any value in that proposal. At the moment, I've got a completely open mind. All I'm saying is I think it's an idea that it would be unwise not to pursue.
And if I can just add on that. I mean, that's exactly what I tried to explain to the Justice Committee. What we are going to do is do feasibility studies in these areas to assess what the opportunities might be, to assess what benefits we might get from justice centres. And that's our intention, to take forward those feasibility studies, engage with partners in there, and bring it back to the STS board in terms of, is this a policy decision on a direction that we want to go ahead in the future?
And I think 2 weeks ago the Law Society said the logical conclusion of what you're proposing is just having one court serving the whole of Scotland. How would you react to that? I mean, there does appear to be a big drive here to centralise, regardless of the challenges that rural communities face in terms of accessing justice. And yes, you want to have the best quality of justice delivered in Scotland, but I don't necessarily accept that it should mean centralising all these courts into one body in the borders, or indeed, as the Law Society suggested, for one court for the whole of Scotland. I just don't accept that. And I just wonder if you have a view on that.
I can't imagine the Scottish Court Service Board ever reaching such a view on a policy. It's certainly not my view, and I think it might be rather a difficult one to implement. I don't take this as a realistic proposal.
I mean, there is an irreducible core of buildings that we will have to operate from. There's absolutely no question or doubt about that at all. And there is no further wave of court closures that are planned after that. What we are doing is going to be looking in 4 areas about how we can actually improve the delivery and justice of that area. That may involve a building or a number of buildings or TV links or a different way of accessing justice. That's what we want to do the feasibility studies to try to understand.
I'm just trying to clarify. So this word, to Ms McQueen particularly, this idea of a justice centre might have satellites.
That's what we'll look at as part of the feasibility study. It may be there's certain types of businesses, of court business that can be done from different areas. That's what we'll try to explore in looking at this whole notion of a justice centre and what that means for the wider community that it serves.
If it's any help, I should mention that when my colleagues and I were working on this civil courts review between 2007 and 2009, we did actually visit a justice centre in England just to see how they worked. And I have to say that there are some very considerable advantages in it, but whether it can be adapted to Scottish conditions is another matter, and that remains to be seen.
I've got Sandra White, followed by Roderick Campbell, followed by Graham Pearson, followed by Lewis MacDonald, so you know where you are, followed by Chick Brodie. Sandra White.
Thank you very much, Convener, and good morning. Good morning, Lord Gill, and good morning, Mr McQueen. I want to thank Lord Gill for his very concise contribution. It certainly was short, but it was to the point, which is I quite like that rather than rambling ones. Anyway, I've mentioned this before in regards. I'm not asking a rambling. I'm just putting forward my statement, and I do thank you for the concise contribution that he's put forward. One of the interesting aspects of the witnesses we've had and the contributions we've had, not just from lawyers but from others, is obviously the access for people, for ordinary people to get justice. And I was very interested in your comment when you mentioned the fact that when we're looking at the 3 high courts and how it moved towards that, it would certainly bring forward less downtime, no gaps, and a rolling programme would be able to be implemented. Because what we hear from witnesses is that the court sometimes isn't an efficient use of time. And I just wondered if you could expand on the comments that you mentioned, the fact that it would be less downtime, no gaps, and you'd be able to have a rolling programme, just exactly what you mean by that and how that would affect witnesses. It would certainly be an improvement, I would imagine, in going to court.
Well, the programming of trial business in the High Court is a nightmare, I have to say, because you can never predict the length of a trial, and the only thing that you can depend upon is that the unexpected is going to happen. you might find that someone pleads guilty halfway through a trial, but by the time the accused decides to plead guilty, the witnesses in the next case have all been sent away because it was expected that the case would go on. These are the sort of ups and downs that happen all the time. If you have a sitting in an outlying court, the tendency is to allocate the trials, and there may only be 2, 3, 4 trials, to allocate them to specific days, because that's just the way the planning has to be done. And so you tend to find that if cases go off, that the court then stops for the day and comes back in the following day. We believe that if we can focus all the work on these centres, then it gives tremendous flexibility, because you've got a pool of judges on hand, you've a pool of prosecutors on hand, and you've panels of jury, prospective jurors coming in day by day, sometimes some coming in the morning, some coming in the afternoon. So you have much more flexibility, and planning is much easier.
And that's fine when I make him back in, but thank you very much. That's,
Well, I'll have to decide that. I have a little tiny modicum of power here, shrinking by the week. Roderick Campbell, followed by Graham Pearson.
Just like to raise a couple of quick questions first for the record, really. In terms of concerns about the press's ability to cover court proceedings, if courts are further away from the local press, what can you advise? Perhaps Mr McQueen can comment on that.
I mean, I think what we can say about the press is that the idea of the sort of dedicated court reporter is certainly a dying breed across a lot of areas. So press are using much more use now of press associations in terms of getting the message and stories for courts. One of the things that we have said we will do is work with press at a local level in any areas where court closures are taking place, to find out if there's a different way that we can actually start to communicate information with them electronically. We have got a longer term ambition that what we would like to have is an online access for the media to secure information about cases and about court outcomes. So I think our longer term plan is much more how do we move this more to an online facility in real time that allows them to access information. But in the more shorter term, what we will be doing is working with local reporters in those areas to find out how we can facilitate a way of sharing with them information electronically.
Thank you. And in relation to police witnesses, again, what can you say, can you update about the strategy for reducing the number of police witnesses called to give evidence?
Yeah, I think there's 2 things specifically I'd say on that. I think one of them are covered in my response to the Justice Committee. One of the very first and simple things that we will be putting in place with the police this year is really what's called a scheduling system for police officers. At the moment, trials are simply allocated at a time that suits the court, irrespective of whether that police officer is either on duty or off duty. Quite clearly, if he's off duty or due to start a back shift, then there could be significant overtime costs to the police. So we are now having an electronic schedule put in place that will try as far as possible to match trial times to the availability of police witnesses. The second big thing which we have had a pilot on and we are now rolling out with Police Scotland, and I think will make the biggest effect, is about trying to stop police officers having to sit about court waiting rooms all day waiting on trials that might never take effect. So the standby arrangements that we will have in place with the police will allow police officers to be deployed to the local court, to the local police station, and they will only come to court when it's known on the day if that trial is going to go ahead. Otherwise, they will just be stood down on the day and they can be put back into operational business. So that's actually been a very successful pilot that we had running across Strathclyde now, and Police Scotland now want to see that rolled out across the whole of Scotland, and they think it will be a significant step in reducing a lot of the downtime that they have for police officers at the moment.
Thank you. In relation to the economic impact of court closures, very recently I've seen a document, the impact of court closures on Cooper, which I believe you've seen as well. It concludes rather strangely by saying that the SCS consultation cited 6 job losses and operating costs saved around $92,000 per annum, resulting from the closure of the Cooper Sheriff Court. I think that's incorrect, isn't it?
Yeah, I mean, well, it's first and foremost, we won't be having any job losses. So there will be no job losses at any of the courts at all when we're in closure. And in all of those cases, the staff will, in virtually every case, be moving to the court where the business is going. And sometimes, due to individual preference, they will be moving to another court. But we are absolutely clear there will be no job losses at all as a result of that. We saw this document that was produced, I think, by consultants on behalf of Fife and Forth Valley Community Justice. And it's an interesting document. It makes a whole range of associations in terms of what cost transfer might apply, what jobs might be related to the criminal justice. And I think where we have some difficulty is actually trying to relate that directly to, in this case, the closure of Cooper. I mean, our view is that people will still be prosecuting in Cooper. People will still require civil litigation within the Cooper area. They will still require the same professional legal advice. Social work will still provide the same pre-court services to accused that are coming before them in terms of Cooper, and they will still provide the same community disposal work after. What we are doing is moving where the cases are being held, the short distance from Cooper to Dundee. So to try to then take that and suggest that this is a £2 million hit on the economy within Cooper, I think we just struggle to see the logic and sense in that.
If we could just come back on that, but obviously if court practitioners are in Dundee, wherever they're spending money, then there might well be a transference of money from the Cooper economy to the Dundee economy.
There may be a transfer, and that's why something that we said that there will be an impact, but our view is that that impact would be quite minimal and it would be quite short term. Quite clearly, others have got different views, and that's the sort of things that are portrayed in that paper.
Well, without getting too heads up into the methodology, the thing I find most difficult to take is the question whether it's short term or permanent, however much it is. Why do you say it's purely short term?
Because I think the market will, in terms of the legal market, will rework itself in terms of how they provide the services. I don't think there's a suggestion that all the solicitors for Cooper are going to close all their offices and move en masse to Dundee. I think their models will change and vary with businesses as the private sector does. So we're not, in our view, seeing it as being a massive move either of the legal services or social work services from the Forth and Fife Valley area to Tayside. I think what we will see is there'll be different ways of working and operating in the future.
And in terms of Plan B, if these plans, for whatever reason, go awry, I think you've already suggested to me that as far as any feasibility study for justice in Fife is concerned, it would obviously include North East Fife in that feasibility study in terms of the delivery. But how will the court service cope if unforeseen circumstances or things don't go quite as well as they could arise?
Sorry, in terms of these recommendations?
Is there a plan B if things go wrong, put it that way?
So if these recommendations are rejected? Yeah, I mean, I think we've tried to be clear in our consultation that our view is that the status quo is not an option. Yeah. So just simply carrying on as we carry on just now is not somewhere we see ourselves being, irrespective of the decision of this committee of Scottish Parliament. What we're trying to do here is to find out, is there a way of designing a 21st century court service that can have investment in the right places, have investment in technology, and take the benefit of the justice reforms that are coming our way. If the view of Parliament is that we remain having to operate from a 19th century court estate, then that's exactly what we'll do. We will continue investing in buildings which we think are inefficient and not well used. We will continue taking big risks in terms of our backlog maintenance. We will have to look very hard again at the headcount of the staff in the organisation to reduce costs. All of these things will have impacts on sitting days and our ability to put justice through. And our view is that we won't be able to make the radical and the transformational change that we want to make, and we will be trying to operate the system as best we can with all the inherent risks that carries.
Okay, I'll leave it there.
Thank you. I've got Graham Pearson, followed by Lewis MacDonald.
Thanks, Convener. And good morning, Lord President, Ms Macqueen, Ms McGregor. There's a couple of areas I wanted to cover with the Lord President and one with Mr Macqueen at this time. The first one was, you mentioned having a long, hard look at the current situation, and you've obviously considered the detail of the proposals. Can you share with the committee how much time has been utilised by you personally in looking at these proposals, and what critical criteria did you apply in making a judgment on the impacts, And finally, if you can, how comfortable are you with the outcome and the recommendations within the proposal?
Well, this has been probably the most extensive consultation exercise that I've had experience of. We started out with initial discussions at board level with the senior management to try to see where the main areas of change could be made. And then when we were just beginning to reach tentative ideas about this, we had a series of roadshow events throughout Scotland, which was not just for lawyers, but for just about everyone who was involved in the justice system in one way or another. And the various ideas were extensively discussed in that. In the meantime, while that was going on, the staff of the Scottish Court Service were building up a statistical and financial case in relation to each of the courts, looking at the question of costs and looking to see where savings could be made. And that was a very thorough exercise. A lot of work went into that, and that led to the publication of Shaping Scotland's Court Services in last December, I think it was. And then after that, we consulted extensively with the Sheriff's Principal, who've got a particularly direct interest in all of this. And then the whole matter was discussed extensively at board level. So I hope that I think, explains to you that we've gone about this in a very thorough and committed way. These proposals have been very carefully thought about. We recognise, of course, that in all change there are pros and cons, and there are advantages and there are also disadvantages. But on balance, our considered view is that this is the way forward.
Thank you for that. In the context of these changes that are proposed, there's been much said about the culture within courts, the people part of these changes. And as I mentioned in an earlier session, victims and witnesses gave accounts of not a particularly positive experience of their involvement with the courts. How confident are you as Lord President that you can bring about the changes to the use of new technology to the extent that's necessary for success, and they still deliver proper trial management and access to justice for the general public?
Well, long before I was Lord President, I was concerned at the way in which court users were dealt with in our court system. And my experience of this goes back to the 1960s. Things have come on so much in recent years. We are now sensitive to the needs of vulnerable adults and vulnerable witnesses. We have systems in place to enable children to give evidence remotely, and we have facilities for that. And I think the court administration is now much more conscious of the needs of the court users and the sensitivities of dealing with disadvantaged witnesses and children. We've also said that in relation to the sheriff courts that are going to be closed, we will provide a video link to the court to which the work is being transferred. And I think that all of these measures will mitigate the impact of these changes. But what I would like to assure you about is that the court service is extremely sensitive to the needs of court users who have special needs. The whole atmosphere is different now from what it was in the old days.
In that context, one supplementary connects to often trials occur in circumstances where juries are present, where the nature of the accused in those trials present very special challenges and fears that evidence will either be tampered with or threats offered within the trial process. Given that you're narrowing down the opportunities for particularly high court trials, but also sheriff and jury trials to particular locations. Do you still feel you'll have that flexibility to deal with those challenges if and when they appear in future?
Well, I think so. I think it's much easier to guarantee that when you have highly focused specialist court centres. Not so easy to do in the outlying courts. Could I just also mention, just if I may go back to what you asked me about earlier, another huge change in the culture has been the way in which complainers in sexual offence trials are protected to a degree that was never the case 30, 40 years ago. And that has been a major improvement in our system.
Final question to Ms McQueen. You probably hear in the earlier session, issues were raised by East Lothian and Scottish Borders about the impact of the proposals in relation to their services. And there was a view that said that it may well be that you're dealing with costs within Scottish Courts service budget, but those costs are then faced by other public services, and in some occasions they'll actually spend more money to cover the savings that you will achieve in your end. It was particularly noticeable that both East Lothian and Scottish Borders felt that the consultation process hadn't been effective and that their voices weren't heard to the extent that they would have wanted. Does that cause you concern? Do you have the opportunity to go back and try and deal with that issue?
I think it always causes me concern if people feel that they've not been a true part of the consultation. And certainly, yes, I will go back and carry on discussions both with East Lothian Borders Council, as I have done in recent weeks. We try to involve the councils at a very, very early stage, right into all the chief executives, way before the consultation, inviting them to all the dialogue events, engaging with their staff, and we've had a level of engagement then on in. I've had discussions with both the chief executives at both those local authorities and assured them that what we absolutely want to do if these proposals are accepted and taken forward is start to look at how their services integrate with the courts in a different area. Mm-hmm. So is it actually truly about making sure that social workers have to travel physically to a court, or actually are there different ways that we can do that business? Now, part of it is our commitment to install video link facilities within those particular areas. So what ways can we actually help them to change the way they integrate with the courts and manage with the courts, and other things that will reduce the concerns about the cost base that they feel that might be transferred to them. So I think there's lots of opportunities for us to address these issues, and I'm certainly working with the two chief executives, and we'll carry on doing that in those areas to reduce and minimise any concerns they have got about a knock-on cost to themselves.
Yeah. Well, I can reiterate they've certainly issued those concerns to me in the last week. Thank you.
On the video links, Mr McQueen, we had from the Cabinet Secretary that something starting in June, and that he would be able to provide us with information about where courts, if they're closed, will have video link set up. And we did want to have that by next week. Will that be available?
If the Cabinet Secretary said it will be available,
if the Cabinet Secretary said it will be available.
I'm quite sure it will be available. I mean, just to be absolutely clear on what we're talking about and clear on what
we're not watching the World Cup. Yep. We just want to know. I mean, it's a serious point. If we're being told that certain courts, if we vote for this, will close as of early next year and into 2015, but don't worry, guys, we're going to have video links in these courts set up by the time or before they close, if they do close. We need to know that.
Yep, our absolute commitment is to provide that in every court by the time it closes. Yep, there is no doubt about that. That's something we've said
if the court closes.
Yep, and we've said that on a number of occasions. And I think what we have also said, and the Cabinet Secretary was talking about, I think earlier, what's currently being installed, and this is the next stage of our video conference in the north of Scotland. Yep, so using the cloud technologies it's described.
Sorry?
The cloud technology.
Clouds?
Cloud, yes. Which I'm not great
I'm
expert.
Out of my depth
I'm a bit like you on that one, to be honest.
And I don't want to know about it.
But this is the next stage of technology to help us with video conferencing and how we can take it out to wider areas. So we have a fairly big programme already about how we increase the video capacity, but the absolute guarantee is that in those courts, if closures do proceed, then we will have a video link facility installed within those areas by the time it closes.
There are difficulties, of course, with video links, as the committee has heard, in the Victims and Witnesses Bill. It's not all it's made up to be. I mean, you sometimes need the person in front of you to determine the validity or otherwise, or the level of credibility of their evidence. Are there difficulties?
I think we fully accept it's not the perfect solution. But I think equally fully accept for the vast majority of cases, it can be a very good solution. Technology has come on leaps and bounds in recent years, from crackly screens and slow-moving images to things that actually now pretty much replicate real life. There has been a strong view by the senior judiciary, and we took them to demonstrations of the latest technology, that actually this was the way forward and we should be making a much quicker use of it. So I think from the senior judiciary, there's a recognition that this has got a real place to play within the court environment. And in recent months, we've started moving criminal appeals now to be done by video conferences. Rather than people being transported all over Scotland down into Edinburgh for a criminal appeal, that is now starting to be done by video conferencing. So we're working with the prison service to install video facilities across Scottish prisons. And I say we're now moving to a position where everyone in prison will now do it by video conferencing. We want to extend that to appeals that are on bail, so that people will simply go into the local sheriff court, whether it be in Aberdeen or Inverness or Dumbarton, and again they will video conferencing through to the appeal court in Edinburgh. So it's not something that's just a wish list that are out there for the future, but something that actually incrementally we're integrating within the way we deliver our service.
I'm going to have to learn about clouds at some point. Lewis MacDonald, followed by Chick Brodie, followed by Alison McInnes.
Thank you very much, Convener. Or President, apologies, I missed the very opening part of your remarks, but I did hear you say that there was a perfectly good intellectual case could be made for these changes, regardless of the budgetary elements. Would it be fair, in your view, to characterise that intellectual case as a case for greater specialisation and centralisation in our courts?
Well, I hope there will be greater specialisation in the courts. I think it's something that we badly need. It's one of the key proposals in the Civil Courts Review to have specialist sheriffs in various subject areas. I honestly can't see the case against that. It seems to me to be absolutely self-evident in this day and age that you should be able to specialise in the justice that you provide to the public.
I note you affirm specialisation, but not necessarily centralisation.
No, certainly not.
Okay, that's the point to which I was seeking to come, because I wonder then, on the same basis of intellectual rigour, do you accept the argument that there may be a tension between increased specialisation in function and maintaining local access to justice within communities?
I can see that.
And if so, do
yes.
you feel the balance in these proposals is correct?
If we were to keep the present pattern of courts, it would be impossible, in my considered view, to have specialisation in the smaller courts. You need the volume of work in order to do that. The problem about we acknowledge the value of local justice and the idea that there should be a pattern of courts distributed throughout Scotland. That's a given as far as the court service are concerned. The problem about the courts that are being proposed for closure is that they are underperforming. They are simply not performing efficiently. More than half of them do not sit for more than 3 days a week. And they simply, the amount of, the volume of business that they do, when compared with the cost of maintaining these courts, is, in our judgment, disproportionate. That's the difficulty in the outlying courts.
I appreciate that point, but I'm sure you will also appreciate that the same comments could be made of quite a number of outlying courts, as you describe them, which are not subject to closure proposals at the moment, and in every sheriffdom, I suspect, but certainly in the larger rural sheriffdoms, there are a number of courts whose performance by the same measure is poorer than some of those proposed for closure. Can you explain to the communities affected by proposed closures why Stonehaven and not another court, for example, or why Arbroath and not Forfar, for example?
I think that the idea is that if we close a court like Stonehaven and transfer the business to Aberdeen, then that in effect means that the Aberdeen court will work more efficiently because it will have less downtime because of the transfer of the work. That's the idea behind all of this.
We heard last week from Mr McQueen and his team that the court in Aberdeen, far from hitting a target of 16 weeks for the calling of trial, is more like 23 weeks. So I wonder how adding extra business is going to increase the efficiency of a court which is already clearly struggling to meet all its
I'm not sure that that's entirely right. I mean, I defer to Mr McQueen's judgment on these statistical matters, but my understanding is that the existing provision in the courts that are not to be closed is more than adequate to accommodate what's coming from the courts that are proposed for closure, bearing in mind that the courts that we're proposing to close account for less than 4% of the whole civil caseload of the sheriff courts in Scotland.
May I also quote, remind you of another comment Mr McQueen made last week in relation to the borders, which was that we are trying to look at how we can best deliver justice in the borders by having one central hub, which will be the main place where we deliver that business. Assuming that's the principle and that principle applies and underlies the other feasibility studies currently underway, do you anticipate, as Lord President, that the consequence of further examination will be further specialisation and therefore a further round of closures of local courts?
Well, I would hope that there will be further specialisation as the years go by, but whether that involves centralising to a greater degree than we are now proposing is an entirely different matter, and that remains to be seen. I think, well, Mr McQueen can answer for himself, but when he was talking about the borders problem, I think what he was saying was that one possibility that could be pursued by way of research would be to have a civil justice centre, a justice centre in the borders somewhere. But that, as I've tried to emphasise, is no part of these proposals.
My final question on capital relates to one of my colleagues, I think this morning, quoted a figure of 53 million as a backlog maintenance cost across the estate, and one of the witnesses who's made a submission to this consultation suggests that some 60 million has been spent on upgrading Parliament House over the last 6 years. I wonder if you could confirm these figures and if people are right to draw conclusions about the priorities that the Scottish Court Service has followed over that period.
I'm happy to confirm both those figures, but also just happy to give a bit of explanation. When I came to the Justice Committee last, I think it was November time, we were looking at the financial planning. We had talked about the backlog maintenance of the court service at that time. I think it was at 57 million. With thanks and support from the Justice Committee, we actually got additional funding last year that we have ploughed into the backlog maintenance. So we've now brought that down to about 53 million in terms of where we currently stand at the moment. Backlog maintenance is a big issue for every organisation that has a large property portfolio. That we carry out periodic consistent surveys of all our buildings to find out that in terms of the Royal Institute of Chartered Surveyors building standards, what work is required to bring it back to a satisfactory condition. Yep, and that gives us our estimating to allow us to plan for future years and decide where we prioritise in maintenance. Now, on some of those things, we have to carry some risk. We have to prioritise what are the most important things, either in terms of legislative compliance or in terms of health and safety. So sometimes we will carry out works in a building to replace electrical circuit boards, where actually people might prefer us to spend money improving things for victims and witnesses. But that's the sort of decisions that we have to make trying to run a big complex estate. So in terms of backlog maintenance, I'm quite clear about where we are and why we're in a particular position. The issue about Parliament House, we are just coming to the end of the Parliament House contract. I think in total the budget for it was 65 million. I think we're expecting the final spend to be in the low 60 million. It's a project that's been delivered on budget, on time and on quality, and I think actually is a tribute to the Scottish Court Service in terms of how they've delivered that. The potted history of Parliament House goes back a little further. when about 10 years ago there was a scheme in place which was going to run to way over, I think, about 120 million at a particular time. That was brought to a stop to allow us to reassess it, to try to look at the best strategy. And at that same time, we looked at a business case to actually move away from Parliament House altogether and look at development on a green or a brownfield site on the outskirts of Edinburgh. The major problem with Parliament House is that it is a Grade A listed building. It's a site of special historical interest, and it should be a landmark building for the whole of Scotland.
Move to a greenfield
absolutely.
site, a bit like going to B&Q.
Had the decision,
line B&Q, but you know, I like the old Parliament House.
Had the decision been to move out of it, essentially that asset would have been left with Scottish Government. The whole building, the infrastructure, the services were shot, there was no fire certificate in place for the building. So the actual cost of moving out was actually going to be as much as the cost of redeveloping it. So in terms of the benefit to the nation, the benefit to Scottish Government's purse, the investment money of the 65 million over that 5 or 6 year period in Parliament House was actually quite a sensible business case decision.
But you would accept the point of view that says that the assets for local communities represented by Sheriff Courts are very often comparable to the value of Parliament House that you place.
They are very often comparable, and that's why we're trying to do a planned investment in that same way to make sure that we keep buildings in the state that they deserve and is right for them.
Right. I was just sort of distracted by moving to a greenfield site with KFC nearby and everything, and it's not got the same status somehow. Chick Brodie, Alice McInnes, Nigel Dawn.
Good morning, Lord Gould, Mr McGregor, Mr McQueen. This hasn't been handled very well, has it, Mr McQueen?
It depends what you're referring to.
Well, the fact that you have had to have meetings recently with the Chief Executive of East Lothian and the borders, and I'll come back to some of the detail, suggests to me that had these discussions taken place before your report, then there might have been less angst, as I experienced in a public meeting and in reports, and there might not have been a need for a forensic analysis by an independent accountant in the case of Haddington Court.
You could suggest that's been the case, but equally you could suggest that we've actually had a very good process of dialogue and consultation, as the Lord President's always explained. I think what you'll always find with any of these issues when there's a difficult decision is that once you get near the decision point, the heat gets turned up. Yep, and I think that's what we are finding. That's what we're in the midst of.
It's certainly not the way I run my businesses, but there you are. Just on the Haddington Court situation, there were revenue expenditure savings of 81,000, of which 34,000 was a non-cash element, i.e. depreciation.
That's correct, yep.
And I understand that 47,000 has been covered, or will be covered by East Lothian Council. The big issue, of course, is capital saving of nearly £500,000 on the building itself. When was it last? When did the Scottish Court Services actually have an independent review of the state of the building?
We commission independent condition surveys of all of our buildings. I couldn't precisely tell you when Haddington was last in that cycle.
Would it surprise you that I was told...
But it would have been...
Sorry,
so we carry out an independent cycle of condition surveys of all of our buildings.
It would surprise you to know that the check on the dilapidation and state of the building was done just 5 years ago, and that £500,000 might seem a bit extreme.
I'm not aware of what that position was 5 years ago. That's the first I've heard of it.
I wonder if I might just take a couple of wider questions.
Sorry, can I just come back just to make one point, which I think is quite a general point that's worth making. One of the things that we have tried to do is to approach this with integrity and professionalism. Yeah, we haven't looked at any costs or financial savings at all to try to somehow bring this together as part of a business case. And I think it's actually related to the point that Lewis MacDonald made earlier on. What we have done is trying to look at sensibly, not about what buildings should be closed because we'll make a financial saving, but actually what's the ideal model for a future estate for Sheriff Courts. And that's why we have looked at courts that sit less than 3 days a week, where we think the travelling distances are reasonable, and we have looked at courts that sit within 20-mile distance of another Sheriff Court where we believe it can comfortably take the capacity. So that's the rationale we've used to include things in. We've not included or discounted Sheriff Courts because they have a small saving or they have a large saving. In some cases, the saving is quite small, so they're not in there for financial reasons. This is not about trying to produce a case to demonstrate the cause of a particular building. And I'm just making that point, just to make it quite clear that we've not done a separate financial exercise just to try to somehow justify recommendations.
No, I understand. Thank you for that. But far be it from me to question your integrity. I'm not doing that. I just believe that early consultation, efficiency, openness, transparency might get it to the end result. And I understand.
Sorry, can I just clarify on that as well? I mean, that's exactly what did happen. I mean, when we came out with the consultation document back in September last year, the exact same figures for all of the courts, the savings, the cost, the impact, was actually part of that discussion and part of that consultation.
Okay.
So there's no question that we've just come out late with a different or revised set of figures.
That doesn't sit in my mind with having to have conversations with the Chief Executive of the Council.
I understand what you're saying.
Right. Can I just, on the wider, the retention of justice of the peace, there's a suggestion that some JPs may resign and may not be prepared to travel. That has a wider implication in terms of statutory declarations and passport applications. What consideration, what conversations took place with the JPs in this particular, across the whole programme?
We've had discussions with the Scottish Justice Association, who represent the JPs in Scotland, over the last 2 years about these proposals and about these closures. I've attended the JP's conference from Lothian Borders to speak with them specifically about these. And yes, you're absolutely right. There's a lot of concerns being raised by JPs, and understandably they're concerned about the closure of Harrington. But it's not been for the lack of dialogue, and it's not been for the lack of discussion with them. JPs are appointed not to a sheriff court, but to a sheriffdom. And within the terms of their jurisdiction, they can serve at any court within that sheriffdom. Now, quite clearly, most people will serve at the sheriff court that is closest to them. But our full expectation is that the revised JP Business Court programme in Edinburgh, if it takes in the Harrington business, that will be a programme that will be open to those same JPs. Now, at the point of unification, where we closed quite a range of district courts, we had these same concerns that were being raised, that Justice of the Peace would no longer sit because the business was moving to a different area. What we actually found is, yes, there was a level of turnover, but we found that many of the JPs carried on and new JPs also came into the programme at the same time. So we have dealt with similar issues in the past, and we've actually had quite a good positive result from it.
Okay, thank you. One last question for Lord Gill. You were quoted as saying that, quote some time ago, radical changes are imminent in the provision of both civil and criminal justice. Were they looked at the same time as we were looking at these changes in the court service?
Well, the whole of the exercise that I've been talking about today has been conducted against the background of the court reform proposals. My own view is that these proposals that I'm speaking to today will greatly assist in the implementation of the court's reforms.
Thank you
very much. Thank you. Alice McInnes, then Nigel Dawn, please.
Thank you. Good morning. I'm in two general questions and then a couple of specifics if I've got time. In a democracy, justice needs to be done and it needs to be seen to be done. And you said earlier, responding to John Lamont, that of course that you wouldn't only ever have one court. But I am genuinely interested in what you would think would be the optimum, whether there are any dangers at all for society generally in justice being delivered remotely, and what kind of safeguards do you think we need to have in the court system?
Well, I think it's quite likely that 20, 30 years down the line, the landscape in the courts may be very different from what we're talking about just now. That's just what happens in a changing world. My own prediction would be that there will be much greater use of remote access to the courts as the years go by. It's the coming thing, and it's to be found in many other jurisdictions in the world. But at the moment, all that we're putting forward is a proposal that appears to meet the needs as they are in 2013, and I would imagine that circumstances will continue to change over time.
So are there any checks and balances that you need in the system?
Well, it's perfectly possible. I'm not saying I'm arguing for this, but I'm just saying that it is possible to have a system based entirely on remote access to courts. I'm not saying that's a good idea, but the technology is there. But I think at the end of the day, Scotland will always want to keep the local link, and that there will always, my prediction would be that there always will be sheriff courts dotted around the country, but placed in locations where the greatest need exists. I mean, that's why Livingston was created as a court centre.
Thank you. And you've touched on my second point, which is about video links. And Ms McQueen, and indeed the Cabinet Secretary earlier today, was assuring us whenever problems were raised that video links would solve it. Is there not a particular role for the court? And again, I mean, well, you've said actually that you think it could all be done remotely. Surely the court has a very particular special role, and is there not something about drawing people into the court to carry out the justice?
Yes, I agree with you entirely. The only point I was making was that the technology is there. I'm not saying I'm in favour of it.
Okay. Thank you. And in terms of the centres of specialisation, you said that you hoped over a 10-year period you would develop these centres of specialisation. Would each of the 16 courts have all of the specialisations?
That's the plan.
That's the intention?
That is the plan.
Okay, but you said you would give sheriff's principal discretion on that?
Yes, well, in each sheriffdom, the sheriff principal has got his finger on the pulse on a day-to-day basis. And what we've tried to do is build in some flexibility in these proposals so that we're not rigidly saying that these cases can only happen in these courts. We're saying that if the need should arise, that the flexibility should be there to enable the sheriff principal to allocate a case to other courts.
Ah, right, but not to determine what specialisms are developed.
No, but the sheriff principal will obviously have a big say in establishing various specialisations within his sheriffdom, when we would look to his judgment in the matter. But we're looking to have specialisation in all the areas like family law, commercial law, child law, that sort of thing.
Okay, thank you for that. And in relation to the High Court proposals, you said that you would consider in the interests of justice sometimes having cases elsewhere. Yeah. Can you give some examples really just of what would be?
Well, we've got in the proposal, we've got the 16 designated courts for, I beg your pardon, we've got the 3 designated courts that in which we will concentrate the High Court work. But in addition to that, there is provision to farm trials out to what one might call satellite courts in sheriff courts within easy reach. If you're talking about Glasgow, for example, the obvious one there is Paisley. But we're also saying that even beyond that range of overflow courts, there will be also the power in the Lord Justice General and in the Lord Advocate to allocate trials to other courts other than those ones if the need arises.
And under what circumstances do you think the need might arise? That's what I'm trying to establish.
Well, one thought that comes to my mind is that you could have a trial where there was some particularly intense local feeling where it would be in the best interest of everyone if the trial were not heard in the area where the crime was committed. I'm speaking purely theoretically at the moment. And that is the sort of situation in which you might say, this trial may take a month, it may take 2 months. Best to farm it out to a sheriff court that's not on the list. And then that way, that trial can take place on its own without clogging up the system in the other courts.
Okay. Thank you.
Nigel Don.
Thank you, Convener, and good afternoon, Lord Gill. I'm wondering if I might start actually with Mr McQueen, if I may. I think, as indicated last time, we're going to have to take the capacity of Aberdeen to take the Stonehaven business on trust, and I do understand that. I've now seen the numbers. I do have to say, though, that my constituents in Stonehaven are not going to regard that as an ideal arrangement, and I think I need to disagree with you, although I can see your point of view on that. I must welcome the idea there's going to be a video link at Stonehaven, and I would just question where else there might be in an area like the Mearns. Others will have their own areas, of course. Could I speak up, though, specifically, Mr McQueen, on the issue with job losses? I don't want to talk about individuals that would not be appropriate. I'm sure that in principle you meant precisely what you said, that there would be no redundancies, people could move. If there are some people for whom that is in practice not sensible, what are you going to be able to do for them, please?
Yeah, I mean, we're working very closely with the trade union side and with every single individual member of staff to essentially find out what the right option is going to be for them. So our first principle is that we would like staff to move with the work, and for the vast majority we have been able to achieve that. For other staff, whether for travel or for personal reasons, their preference may be to move to a different court. And again, for a small number of staff, we've looked at that. We are now putting arrangements in place to make that happen. If we have some members of staff, I think there might be one that might fall into this category, and I say I don't want to go into individual areas or whatever, who genuinely believes that move to a different location is not the right thing for them, we may help them to try to find a way to leave the organisation early under some sort of voluntary type scheme. It's not something that we would push at all. It's not something that is a priority or an issue for us, and it would only be explicitly if the individual on the trade union side felt that was right for that single person. But in 99.9% of cases, we will be moving individuals to a location that works best for them.
Thank you. Let's hope we don't have to return to that issue. We will see. Clearly, if the Stonehaven Court is closed, we will have to worry about the building, and I've no doubt that is a discussion which we will have lots to say about. I'm wondering, though, whether I can turn to Lord Gill and ask you, Lord Gill, please, whether you see any scope for, in particular, civil matters coming back into the community. Because it does seem to me, I don't think I'm the only one who feels that some of what goes to court could equally well be sorted almost in a solicitor's office if all the parties were there, or possibly in a local hall if we really needed some kind of public. And there's really absolutely no need to disappear off to a court, local or otherwise.
Well, I agree with that. In the Civil Courts Review in our report, we didn't argue in favour of compulsory mediation or compulsory ADR. We thought that was not such a good idea. But what we did say was that every encouragement should be given in the court system to get cases out of the court and into other forms of dispute resolution, like mediation. In addition to that, the role of the summary sheriffs is going to be vital in all of this, because since the summary sheriffs will be dealing with low-value claims, I would expect that one of their initial tasks will be to adopt streamlined procedures and to have procedures that are as informal as possible without prejudicing the just solution of the case. And it will be up to the summary sheriffs what they make of this job, but I think the opportunities are there to deal with small claims in a completely new way.
Might that include them as the summary just as going to the claim rather than the claim having to come to them, do you think?
That certainly wasn't any firm proposal on our part in the report of the review, but I can see that would be a very real possibility.
Yeah. Thank you.
And I don't rule it out.
Yeah.
There's nothing in the law that would prevent it, as far as I can make out.
That's great, thank you. I said summary justice, of course I meant summary sheriff, but thank you. Obliged.
Really, it's further to that, because I had understood from Sheriff Drummond, we weren't just talking about ADR or mediation and summary sheriffs, but that a sheriff, you would require a change in the law to allow a sheriff to say, perhaps with the leave of the sheriff principal, that this is a court for the purposes, not just for evidence taking. Just to clarify for me the position, what is the status? Can a sheriff at the moment just say, well, the harbour at Eyemouth, or, you know, Broughton, the village hall at Broughton is a court for the purposes of this? Can that be done just now or not?
I read Sheriff Drummond's evidence. Enjoyed it very much.
I know you would.
And he makes the point that instead of asking the litigants to go to the court, the court should get out and go to the litigants. And particularly in a rural sheriffdom like his, there's a great deal in that. He suggested that it would require legislation. I'm not so sure of that, but the matter is being investigated because it was discussed in my private office the other day and we're looking into it.
Excellent. I knew Sheriff Drummond would be worth his weight in gold coming to the committee. I'm going to conclude there. We've had a very long session and I want to thank you for giving your evidence. Again, thank the committee for their questions, and I'll just suspend for 3 minutes to allow witnesses to move out. Thank you very much. It's been a long morning. We're now moving on. Item 5, petitions, 2 ongoing petitions. The first is PE 1370 by Justice McGrahy, calling on the Scottish Parliament to urge the Scottish Government to open an independent inquiry into the conviction of Abdelbaset Al-Megrahi for the bombing of Pan Am Flight 103 in December 1988. You'll see from paper 3 the petitioners are asking the committee to write to the Scottish Government, asking whether it agrees with petitioners' claims it has powers under the Inquiries Act 2005 to appoint an independent investigator, and if so, whether it would be willing to do this to investigate the petitioner's allegations. And I first of all make a declaration that I've signed up to the Justice for Megrahi campaign. John Finney.
Thank you, Convener. I'd like to comment on the very useful paper that's been provided by the Justice for Megrahi Committee. I know the paper will be on the public record, but with a bit of the indulgence, if I can quote some of the passages I think that are certainly important to me, and they relate to comments that the Justice for Megrahi people have never asked the Scottish Government to investigate these matters themselves. That is on page 4, Convener, first paragraph headed up the Justice Directorate, and it's the second sentence in that paragraph. Again, moving to the next paragraph, I think we should be concerned if they are concerned that the Justice Directorate is, and I quote here, consciously misconstruing the request that's been made. I think it's helpful that there's an acknowledgement in the next paragraph that the government admit that such powers of investigation do exist under the 2005 Inquiries Act. Perhaps the section mentioned reflection there is the one that gives me page 8, Convener, second sentence, paragraph headed reflection. And if I may just read the second sentence, it poses profound and basic questions we ignore at our peril, namely, what do we perceive justice to be? What role ought it to play in our society, and whom should it serve to exist? It then, in the next paragraph, refers to, and I have to say the phrase, one misguided decision in a showcase trial. Convener, there's no issue that I am asked about more when in conversation with anyone. I mention I'm on the Justice Committee, that's what committees I'm on. People always have a view on this, and I have to say, almost without exception, that view is summed up by the phrase, one misguided decision in a showcase trial. I could go on at length there. I think there's an interesting question posed by the Secretary, Mr Forrester, when he talks about the standards of professional responsibility and statement of essential duties and rights of prosecutors, page 10, second paragraph. And I would query what avenue of redress there is there, because clearly it's a matter of public concern if people, eminent people such as the Justice for Megrahi people, feel compelled to put phrases like that in a public document. So, with regard to the covering paper from the clerk, I certainly would be very supportive of writing to the Crown Office Procurator Fiscal Service asking for comment on the matters outlined in paragraph 10 there, and I hope the committee would support that.
Yes, Sandra White.
Thank you very much, Convener. I hear all that John has said, and obviously, you know, quite familiar with the petition, as I was on the petition committee at that time. I note on page 2 regarding police, and I'd just like a wee bit further information, Convener. Apparently the allegations have been taken forward by the police and investigations are ongoing. Do we have an update on that particular part?
I'll just check with you.
Is this what John was talking about? Something about...
Yeah. Police investigating a detailed meeting between Justice McGrahy and the police officer on pages 9 and 10.
And is it investigating the whole criminal? Against in the Crown Office. Yeah. Yes. Sorry. Yes. Just say a bit more. Yes, if you like, so it's on the record.
Oh, no, I just wanted an update on that in regards to, you know, where this is, and, you know, the investigation is, and you know, I think the committee's wishes to keep the petition opened. I think the committee's wishes to keep the petition opened. We're writing the COPFS, you know, in what terms would we write regarding that? I don't think we, well, certainly I don't know the proper procedure, but as a committee I don't think we can ask for an investigation for, i.e. allegations, but I think we could certainly write to the Crown Office in regards to some of the issues.
The suggestions that we were writing, I'm just asking what the outline just from where he was told to go.
Sorry, I'm having one. I wish I had one of the things the BBC has, you know, where you have the little thing behind your ear, but I'm having to lean over and see what's open to us. Roddy, yes.
I heard what John Finney's had to say in the matter, but, and also listened to what Sandra said briefly, but for myself, I'm not happy that we should be writing in terms of asking for an account of public criticism of JFM from the Crown Office. I think that is a spat, but I'm not sure that I want the Justice Committee involved in that spat.
Well, I agree with that. What other else do you have to say? What you think we ought to do?
B, C, and D, I've kind of fairly happy with. I think, to be honest, 10 B, C, and D.
John.
Again, I hear what Rod Campbell says there. However, this is a matter of public protocol, how people respond. And we would need to be reassured that if a citizen, never mind an organisation, tenders a confidential matter to the government, that if, as is asserted here, the response isn't for the government to go public by way of a newspaper article on that. Convener, the issue of item C and the suggestions there about JFM, Justice McGrahy, being informed of developments, this is entirely in line with the good practice that we've heard in relation to the Victims and Witnesses Bill coming. So I don't think that should be in any way challenging.
Well, we had from Rod, not unhappy about to write to the Crown Office Procurator Fiscal Service what resources have been allocated to the investigation of the JFM's allegations, whether it will keep JFM informed of developments, and whether it's instructed the police now to proceed with investigation into JFM's allegations. I think that's fair enough to the Crown Office. Now, with regard to the Scottish Government, I think I'm looking at this, whether you would consider writing to the Scottish Government on behalf of the business for its views as to whether it has power to appoint an independent investigator, just its views. That gets that shot once and for all. I mean, either they have powers or they don't have powers. What do you think?
To the Crown Office. You know,
well, we've done that. COPF has...
the one that we were talking about, B, C and D, I would certainly be supportive of that.
You're right.
Where it gets us basically to write to the Scottish Government in regards to his powers to appoint. I'll go with the wishes of the committee.
Well, they're asking us to write to the Scottish Government to ascertain whether it accepts the campaign's assertion that it's the powers under the Inquiries Act 2005 or any other act. Well, what powers it has, maybe we just say what its views are regarding any powers it may have to appoint an independent investigator into the claims. Now, we're going to get that's a fact of life, the answer we get back, one or the other. They either have it or they don't have it. But I think we might be in a position to ask. John?
Suggestion in this paper, in the last paragraph, paragraph 4, second last paragraph, is that the government has acknowledged that in response to a parliamentary question. And that to question 3 page 4. Second last sentence, really, effectively.
I don't know what that question says.
Of course, the issue is not whether you have the power; it's whether you choose to exercise the power or not.
Well, it's an inquiry, not an independent investigator.
I think that was about instituting an inquiry, not an independent investigator.
Right, okay.
I'm very sorry we don't have the actual question and answer before us. I think we just seek clarification about whether they have powers under statute to instigate an investigation. And it's an investigation, not an inquiry into the entire McGrahy thing. We do know that there are powers actually, limited only, however, to those matters that are not reserved. So are you happy if we write to COPVS and the terms decided, that is in terms of BCD and in paragraph 10, and secondly to ask the Scottish Government to comment whether they have powers under any statute to appoint an independent investigator into the allegations made by the campaign. Okay? In which case, I hardly need to ask you for keeping it open, because we're going to do stuff. So we're keeping it open. Thank you very much. Now, moving on to PE 1449, Accountability Scotland, which calls for an independent Scottish Ministry of Justice Council when the UK AGTC is abolished. The committee will remember that we recently considered a Public Bodies Act consent memorandum of a UK order abolishing the AGTC. The Scottish Parliament gave its consent to the order being taken forward 21st May. The order is still to be passed by Westminster. We've also been in correspondence with the Minister for Community Safety and Legal Affairs to establish what arrangements will be put in place after the abolition of the AGTC. The Scottish Government intends to create an interim expert advisory committee under the new structure for devolved tribunals has been created. It then intends to create a replacement Scottish Committee for Ministers of Justice and Tribunals. The petitioners have asked the opportunity to comment once details of the interim expert advisory committee became known. Paper 4 therefore suggests we could write again to the Minister asking him to keep us informed of any developments with the interim committee. And of course, if we do that, any responses in the public domain, what have you got to say about that? Content? Item 6, we're asked to consider our approach to tribunals, and this means that we now move. I was just getting to it, Ned. I have so many carers around me. I'm now moving into private session for item 6. No, I was remembering it.